do.
Yes. This hearing is in the matter of CFI 048-2018 before Justice Sir Jeremy Cooke. It is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Pinson Masons LLP. Lead counsel is Tom Otago Smith QC. The defendant is represented by NEBI & Co. Solicitors. Lead counsel is Nigel Jones QC.
Thank you very much.
Thank you.
Thank you. Your Honour, thank you very much indeed. And that, I think, completes the introductions sufficient from me as well. So, Your Honour, can I simply say this, that my camera is fairly focused, and therefore for me to look at documents I have to look slightly to one side. So if that appears to be rude, I'm not looking away from you deliberately, but that's just a function of the setup.
That's fine, thank you very much. I appear to have a bundle, an electronic bundle that runs from 1 to 2238. Is that what everybody else has?
I think it is. If it runs through from 1 to section J, I think it's.
It doesn't appear obviously to be divided into sections, but when I looked at it on the case management system yesterday, it was. But if you're referring to something, if you can simply go by the page number,
Certainly.
Going up to 2238, that would help.
That looks right. Your Honour, thank you. I'm looking at case lines, but which has got the section numbers. But if you're honest looking at a PDF, I don't think it will have so. Thank you. Well, then let me begin, because I'm going to sketch out, if I may, what seems to me to be the agenda points for the day. We're listed for 4 hours, and therefore I'm going to hope to finish what I want to say in about an hour, subject obviously to any direction that Your Honour wants to give me along the way. And I'm hoping, therefore, that the timing we've provided for you is going to be sufficient, both for questions and decision time and any judgment time. So may I start with some opening remarks and a proposed hearing agenda, and then I'll try and work through it logically. This is an application by EGDL to vary the terms of a search order and subsequent orders, which Your Honour made in 2018. It's comprehensively opposed, and that there is no suggested accommodation in respect of any part of it, and I'll come on to explain the various parts in a moment. So the short point is that SCAT wishes to continue to make full use of the documents seized in 2018. That is the key issue between us. So the matter comes before you in August, for which apologies, but SCAT's counsel, I think, weren't available from now until later in September, and that delay was thought to be inappropriate. So that's why we're here at this particular stage. So my agenda for today falls into 5 categories. So the general introduction, the facts and principle documents, which I will take you to, what I'm going to suggest are the key issues that Your Honour may wish to address, possibly, if I have time, but it's not terribly important, comments on Learned Friend's skeleton, and fifthly, what the court should do. So I'm going to suggest that the key issues which the court has in mind when we get to them fall into 4 categories. There are some sub-issues, but these are the 4. First of all, does the court have power to grant this application? And that is broken down sensibly, I think, into 2 sub-issues. The first is, what's the proper construction of the conduct of claims order? And if necessary, along with it, the conduct of claims agreement. And the question then addresses what Mr. Montague Smith has suggested, that is to say that we are barred from making this application. So that's a question of construction, I think.
Well, it may be more nuanced than that, may it, Mr. Jones, because it may not be a question of an absolute bar, but whether the overall effect of that agreement has a an impact on the court's discretion or decision making more generally?
Of course, nuance in this, but I'm addressing at this purpose. I'm going to get on to what the court should do, which gets one onto discretion.
Yes.
And of course, when you get onto discretion, I couldn't cavil at the proposition you can take in anything into account that you think is right to take into account. I'm just addressing the threshold question,
Yes.
which I think SCAT has thrown at us, which is, are we permitted to make this application at all?
But I think what I'm suggesting to you, Mr. James, is a further step in the sense that although there may be room for variation or supplementation of the orders made by virtue of the terms of the claims conduct agreement, the overall effect of the agreement may nonetheless be to suggest that that's not an appropriate thing to do.
I understand. I mean, I'm not. I'm sorry. Perhaps I didn't make myself clear. I'm not resisting that proposition. I just, in my mind, have seen it as part of the overall discretion issue rather than a construction issue. But,
Okay.
but Lord, you know what? I think perhaps that's a label question rather than a substance question.
Very good.
So my 1B was: is there a procedural threshold which governs us? In other words, a sort of change of position, change of circumstance, procedural threshold. But I don't think that's terribly relevant. But I mentioned it only in case Your Honour wants to have it in mind.
That plainly is a change of circumstance.
Yeah, I was hoping that was the position, but I've put it on the list. But I won't trouble you with it when we get to looking at the detail.
Yes.
So then issue 2 is: what is the status of the revenue rule and the revenue judgment in the DIFC?
Yes.
And really, I think there are 3 separate sub-issues here. Does the relevance of it arise at all in the light of the paragraph 4 of the conduct of claims order? 2, SCAT says that this is the legal question arising. SCAT says, contrary to our view, that the question of the application of the revenue rule does need to be resolved. And they say when it is resolved, it will be resolved in their favour, i.e. that there is no revenue rule in the DIFC. And I simply want Your Honour to know that is controversial. But I'm not asking you to resolve it today, and neither is Mr. Montague Smith. So, and it seems to me not only is neither party asking you to resolve it, I'm not sure you could resolve it sensibly in a 4-hour hearing. In any event, you'd have to do a mini version at least of what Justice Andrew Baker did in England, and ask for some cross-serve submissions and so on and so forth.
Yeah, well, I'm not going to decide that today. I tell you that now.
But if I may say so with respect, utterly unsurprised by that, and I wasn't asking you to do otherwise. So, and then the third question is: what are the case management options for resolving some part of issue 2B? And let me just say what I mean by that. Is that SCAT's taking the point that the application and or the existence of the revenue rule in the DIFC cannot be resolved at this hearing. Now, as I said, I agree with that. You can't begin to resolve that today. But it also says you can't resolve it until the stay is lifted. And I'm not at the moment persuaded that that is correct. Because you might take the view that there are 2 separate points to be considered: whether there is a revenue rule at all in the DIFC, in other words, the simple threshold point. And the second question is whether the claim is caught by it, which is a different point. And at the moment, this is not for today, but it might have an impact on how you wish to proceed in the future, potentially. I don't see any immediate reason why, if the court thought it right, in order to make a final resolution about the search and seed orders, that it couldn't decide the basic question of whether the DIFC had a revenue rule at all. Now, that would be a separate question from deciding how it would be applied to the facts of this case. I'm not inviting you to do that. I'm just saying that I think the point that Mr. Montague Smith is raising is a bit of a blunt instrument to say that it can't be looked at, or no part of it can be looked at, until such time as the stay is formally lifted, which we know can't be, and we agree, can't be until after the appeal's resolved, or the application for permission. I'll come back to that in a minute.
Can I ask a question at this point? Because
Of course you want it.
I'm unclear whether there's a dispute between you as to what the effect, perhaps that's a silly question, perhaps it's obvious there's a dispute between you as to the effect of the Baker judgment, if I can call it that, when if finality is reached in the sense of an appeal resolved which upholds it or permission refused or whatever, when finality is reached, we have obviously a holding that is valid in the UK. Is there a dispute as to whether that is a finding of law on the basis of what he's decided, namely admissibility, justiciability, or whatever, in terms of paragraph 5 being binding so far as the DIFC is concerned?
I think there is. I'm getting some feedback. There is a dispute between us about that, and I have it in mind to take you through the basics of that in a submission in a few moments. So I make it clear that whether there is or is not a revenue rule in the DIFC will be controversial in due course, should we ever need to get to it. My primary position is we never will, because the fate of the DIFC proceedings is already predetermined by the English proceedings. I'll come back to that subject to the appeal point. One small glancing point, if I may, along the way here. It's said by Mr. Montague Smith in his skeleton argument that the appeal is on foot. Obviously, you're all aware of the situation. There is no appeal on foot, if I could be pedantic about it. There was an application for permission which has been rejected on detailed and reasoned grounds. An application has been renewed to the Court of Appeal, which is not yet resolved. So I just want, I know it sounds a fine pedantic point, but it is an important one, that as matters currently stand, there is no appeal on foot. There is simply an application for permission as yet unresolved. Now, that doesn't affect the stay, don't get me wrong, I'm not trying to go behind that, but just the use of language, we need to be a little bit precise. So my third issue, which I will be dealing with either as a separate one or along the way as I go, whichever looks at the time to be more convenient, is the basis of the grant of the original search order and the subsequent orders. And now, obviously, when I say that, I've got to speak with care, because when you made those search orders, the first one, which was ex parte, I wasn't there. Your Honour then knows, may remember, that I came in on the first inter partes hearing in July, I think it was, 2018, and there were then a series of orders, and we'll look through all of those in a few moments, but culminating in one in December 2018, which we resolved on paper. And that's the one which gave permission for the US and the use of the documents in the US and Malaysia. But so
by consent, weren't they? Most of the variations were by consent, as I recall.
They were. Most of what happened in the interim were all by consent, and Your Honour will remember that the principal focus was setting up, as it were, the machinery by which we were going to weather, on both sides, the management of 16 million documents, which I think was the issue. So. But my caution, and I'm going to come back and express my caution, is I'm going to say to you what I think you were addressing in 2018, but you may very well have your own view about what you thought you were addressing in 2018. So I just say as a matter of courtesy that I accept entirely that I will make submissions, but subject to you telling me that I've completely misunderstood. I'm not inviting you to say I've misunderstood it, but I do accept that you will have your own recollection of what you had in mind.
Not and then, respect.
I've just been cautious, because it's very difficult to say to a judge what they thought, because they may have a better view than me about that. And issue 4 is really the issue of discretion and what you're going to do, and what the options are. So that is what I've sketched out for myself as the principal points for today. So if I could make a start. On my what I call issue 1, which is the sorry, my next agenda point, which is the principal facts and documents. So let me assume that Your Honours had an opportunity to read the skeletons and look at some of these documents, but I still think it may nonetheless be helpful for you to look at them in greater detail. The documents that we're going to look at are properly referenced in on page 6 of our skeleton argument. So if I'm not suggesting Your Honour needs to keep that open the whole time, but there are cross references there if that's of assistance. So the first document I want to take you to is in section E that we're calling it, but it's tab 20, and for page numbers it's at the passage I want to take you to is 1287. The document itself begins at 1282, and a lot of this is in fairly formal terms.
Sorry, I'm not with you yet.
I'm so sorry.
I'm taking a long time getting there. 1287.
1287. So this is your, if I may call it that, your first search and seize order made ex parte on the 27th of June. And I've taken you to page 1287 because I want you just to remind yourself of the standard variation and discharge provision, paragraph 25.
Yes.
And if you just scroll down to page 1290, you will also find the undertakings page in fairly standard form, but please, if you would note paragraph 2 of that, which we have suggested it is a permission to deploy the documents in parallel proceedings in onshore Dubai, but that's in effect what it says. It's not, of course, in those terms, but it's a relaxation. It's expressed as a relaxation of the standard undertaking, but that's in effect what it does.
Yes.
Now, could I invite you at this point, please, to go to if those of you who are following me on the case line, this is to tab D for Delta 19, but for Your Honour it's page 1181.
I'm sorry, it's taking me a long time to maneuver.
I will try and keep my eye on you to ensure that I don't rush ahead. 1181 is the one I'm hoping we can
find. We're
find.
looking at the minutes of the transcript, so to speak.
It's the closest we have to a transcript of the ex parte hearing.
Yes.
And the passage, you will have read this passage quoted in our skeleton argument, but here is the source material, and it's really the first 60% of the passage in the middle of the page where Mr. Montague Smith said nothing has been served yet. So if I can invite Your Honour just to read that to yourself down until we reach the expression, the application for attachment order. Once you've got there, I don't need you to read further.
Thank you. Yes.
Then if Your Honour would go to 1184, so just scroll 3 pages further down, might be quicker than trying to punch the page number in. and it's the penultimate answer from Mr. Montague Smith on that page, beginning with the words "thank you." If you could read that.
Yes.
So, well, I'm going to return to this point a little later, but the key point I want to make here is that as I read these exchanges, Mr. Montague Smith was addressing what he understood would be a concern for your honour and any court, which was the proposition of multiple overlapping proceedings in different jurisdictions, not normally permitted, and was justifying that there would be multiple overlapping proceedings in 3 jurisdictions, not on the basis of forum shopping, which you wouldn't have permitted, I would venture to submit, but in relation to concerns about enforcement alone. So the key message you were being given was that this was an enforcement question, not a forum shopping question. And I'm sorry to use that language, but they're good labels, so I'm going to come back to it. So if we now go, please, to page 1300. So this picks up the second order that you made, or the first continuation order. And for those on case line, it's E tab 22. And if you want to go to page 1300, as I've suggested, you will see there paragraph 2. So this is the standard undertakings page again, but paragraph 2 is in a different form from the first one. And the first one related to the Dubai overlapping proceedings. This one includes the English courts. The first permission in paragraph 2 did not, that you first looked at.
Sorry to interrupt, Nigel. I'm not sure that's quite right.
No.
Have I misunderstood that? If I have, let me just check. I don't think any point turns on it. I was just, as a matter of fact, pointing that out to you. But if I've misunderstood that, I do apologise.
Sorry, paragraph 2, page.
You're quite right. You're quite right. I've misled myself, and Mr. Montague Smith's quite right to pick me up on it. No, as I say, nothing turns on it. I was only just taking you through these orders.
England and Wales and Dubai both times.
Yep. Your honour's quite right, and Mr. Montague Smith's quite right.
Yep.
So now then there was another order which I'm not going to take you to, which we've got as tab 23. But if you wanted to note the page, it's in our paragraph 9 of our skeleton argument at page 1311. And the next one is in August, and I didn't take you to that. It's E24 at page 1319. And the only reason for noting those as we've gone through is that all of these orders contain the standard provision for discharge and variation. That's the only reason to take you to what I'm calling the intermediate orders. There's nothing else turns on.
No, understood.
And then just finally then, perhaps you should see this one, I think, in its original form, which for us is E26. And for your honours, going to start at page 1349. And the reason I've taken you to this is that it's an order with reasons, and therefore your honour may want to be reminded of the reasons. So this is an order in December 2018 on the papers, which permitted the use of the documents in Malaysia and the USA. So in that sense, different from the use in the overlapping parallel proceedings, which were intended to be brought against the same defendant.
Yes.
So if you've found your way to 1349, which is note the beginning of the document,
Yeah.
I think for your honest purposes, I just need to be in a position to remind you of what you said at 1353 and 4.
Yes.
Now,
Right.
Your Honour, if you've looked at this in preparation for today, I'm certainly not going to read it all out to you. If you haven't looked at it in its original form in prep for today, might I invite you to do so and just read pages 1353 and down to the end of paragraph 8 on the next page, page 54, 1354.
Yes, thank you. I'll do that. Yes.
Now, Your Honour, the reason I've taken you to that, which is self-evident really, is that there is an obvious difference. Its relevance will be a matter for Your Honour to judge, the relevance of the difference that is, but there's an obvious difference between what you did and said in relation to the DIFC English and Dubai proceedings and what you said here in relation to Malaysia and the US. So I'm acknowledging that difference. I've taken you to the source material, and in due course I'll come back to make submissions about it. So I've already made this point. The 5 search orders that you made all have a standard provision permitting the applicants, that is to say, by applicants I mean us in this context, EGGL, the defendants as they now are, but today's applicants, permitting them to apply at any time to vary or discharge those orders.
Yes.
As a matter of construction, I'm not sure if this is anything other than stating the bloody obvious, but they are stated to be and are 2 different things. You wouldn't call a complete discharge a variation, but anything less than a discharge would be a variation. And that standard wording is no doubt used for very good reason. So let me now come to the conduct of claims order. And those on case line will find this at E27. And Your Honour's going to find it at page, I think 1356 is the best place for you to start.
Well, I've actually printed it out because it seemed to me to be pretty key.
That I'm very grateful. So let's just walking through it for a moment. Page 1355, which is the start. The only thing to note from this is that we know that the expression previous orders means everything that you've said up to that point in reality, but beyond that, it has no function for us. Over the page on 1356, I would invite Your Honour to walk through with me, if you will, paragraph 2 on page 1356.
Yes.
The DIFC claim has stayed until 21 days after decision of the English High Court on the merits of the English claim, save that the previous orders shall remain in full force and effect. The parties may apply to vary or supplement the previous DIFC orders, or 2. That's really directed to SCAT, I think, rather than the parties generally. and C, the parties shall remain obliged to comply with all the terms of the previous orders as varied or supplemented from time to time, or any subsequent orders made by the court. So let me see if I can capture what in our submission that means, is there would be a stay of the DIFC proceedings until 21 days after decision of the English High Court. We know that from the Conduct of Claims Agreement, which goes into a little bit more detail, the High Court for this purpose is going to include the Court of Appeals. So I'm not emphasising those words for any purpose. Now, it cannot have been intended that the DIFC claim would remain forever in limbo, and therefore the way I'm going to invite you on to start by looking at this is to say that a dismissal of the English claim must fall within the expression which we see in paragraph 2. That's my first point. I'll come back to develop that in due course, but that's the first point I ask you to note. There are then 3 exceptions to the stay, and the fact that there are 3 exceptions is clear from the expression "save that" in line 2 of para 2. The first was that the previous orders shall remain in full force and effect. Now, that expression must, we say, necessarily include the ability of the defendants, that's to say the applicant before you, but the defendants then, to apply to stay or discharge. If somebody wanted to have the previous orders remaining in full force and effect, save for paragraph 25, that would need explicit words, and those explicit words are not there.
Yes.
In any event, paragraph 2 little b, all parties were given the express right to apply to vary the previous orders.
Yes.
So I am agnostic about which of those should persuade you that what I'm doing is justifiable, which is Mr. Montague Smith's first threshold he says I can't cross. Yeah. Because I'm not applying to stay. I'm sorry, I'm not applying to discharge. If and in so far as Mr. Montague Smith is able to persuade you at all, which I hope he isn't, that what I'm trying to do is to, as he put it in one of his paragraphs, to denude the order of any effect. In other words, the equivalent of a discharge, if that's what he's saying. If I have to meet that point, I'll meet it by saying I'm entitled to do that, because paragraph 25 of the orders has been expressly and explicitly preserved. But I don't think we are doing that. So I'm not shifting my ground here. I'm not saying, okay, I'll make it a discharge application. All I'm saying is this is a variation application, but if there is anything at all in the argument that I can't do it, because it's a big variation as opposed to a little variation, and I'll come back to that in due course, then I just don't think this is an objection open to SKAT at all. But there we are. It's pretty clear. What we are applying to do is plainly to vary an existing order.
Yes.
But insofar as Mr. Montague Smith persuades you that the practical effect of it is the equivalent of a discharge, which I think, if I may say so with respect to him, is a completely wrong submission. But if he gets anywhere close to it, I would be entitled to do that anyway. But that's all I need to say. It's not my case that I'm applying to discharge. Now, under paragraph C of 2, the parties were obliged to comply with the terms of the orders and with the terms of the orders as varied. So what this is suggesting, I would very respectfully submit in the clearest possible terms, is that the claim was ported to England, but full control of the search and seize order with all your normal powers over it and the party's normal ability to come and ask you to change it, vary it, discharge it, suspend it, or do whatever else they wanted, remained with you. and remained with the DIFC. That's plainly what this was intended to do. It was never intended, and on its face provides no support to that proposition, that in some respect or other, the effect of the orders was going to be made such that they could not be subject of today's application until such time as the stay was listed. So it's quite clear from this, I invite you to say, that the control over the orders remained with you, or the DIFC, your fellow judge in the DIFC, and that there is no inhibition on your ability to do anything with those orders that you would otherwise think proper to do. A different question whether you think it's proper to do it, but there is no inhibition on your judicial power. Now then, could we just note, going back to page 1356, which your Honour has printed, note paragraph 3. Yeah. So this is the continuation of the stay, if you like, and then go to paragraph 4. Upon the termination of the stay at paragraph 2, and if applicable, paragraph 3. So in a sense, we just don't have to debate what that is for the moment. Upon the termination of the stay, judgment shall be entered in the DIFC claim on the same terms as any judgment entered by the English courts, and there is liberty to apply for that purpose.
Yeah.
Now, the same wording is essentially mirrored in the agreement which is attached to this order, and Your Honour may have noted, as you printed it out, recital B. That's on page 1358.
Yeah.
The parties have agreed that the claimant will proceed against Elysium Dubai, I'm calling that EGDL, and Elysium Properties in the English High Court, and that any resulting judgment from the English Court and the findings of fact and law on which it is based shall be binding and enforceable in the UAE. So here, this is not limited to binding and enforceable in the DIFC. It's the UAE generally, and that includes the DIFC. So, so the agreement between the parties is necessarily wider, and the reason for that is your Honour wouldn't have been making an order,
yeah,
in relation to what would be, as it were, binding on a differently constituted court onshore Dubai. So the difference between the wording is explained by that, but they give you precisely the same message. And we know from clause 2.5 little a of this document, so that takes Your Honour down to page 1361, 1361. If and insofar as it's relevant, that all findings of fact and law reached by the English courts in the English claim shall be binding on the parties, plural, both sides.
Yes.
And they will not make an allegation of fact or law inconsistent with any judgment handed down by the English courts.
Why is there a difference between paragraph 5 of the order and the agreement in that respect?
Your Honour spotted that. I spotted it. I can see a logical reason for the difference between recital B and clause 4, paragraph 4 of the order. I can't, on the face of it, see the logical difference in relation to this. I could have a go at it, but it doesn't seem to me there is an obvious logical difference.
No.
But I think there is an obvious logical difference for the paragraph 4 recital B difference.
Yes.
But the agreement certainly is clear. But I don't think, for practical purposes, anything turns on that. I've only taken you to clause 2.5 precisely because it's different from the order, and I didn't want simply to rest on the order and not bring that to Your Honour's attention. But you already spotted it anyway.
Yeah.
Now, I'm going to submit to you that the proper construction of the 2019 order is plainly that the fate of the DIFC claim was agreed to follow the fate of the English claim. This is what I would call in an insurance case, as your Honour will know, a follow the fortunes provision. I know that's a phrase known in insurance, especially for reinsurance, but it looks to me as if it's a follow. That's what I'm asking you, Honour, to conclude. That's what it was designed to do.
My recollection is, Mr. Jones, that the follow the fortunes clause had one of the exceptions to it was differences in governing law, wasn't it?
Well, that's precisely it. That's a very good point, and I don't cavil at that, and I'm not concerned about it, because in fact, when you look at paragraph 4, yes, this whole distinction raised by Mr. Montague Smith about the difference between lex causa and lex fori doesn't impinge on paragraph 4 at all. It's just a bad point. I'm sorry if that sounds a bit robust, but it doesn't affect paragraph 4. Paragraph 4 is very clear.
Yes.
Now, there is a marginal point that I've noted. If we're talking about what language is and what it means and what it might mean, paragraph 4 talks about there being a judgment entered into the DIFC on the same terms as any judgment entered by the English courts. Now, that's actually slightly curious wording, because I think, I haven't looked this up specifically in relation to the DIFC, but my instinct would tell me that you don't enter judgments, you hand down judgments and enter orders, if you like. But this can only be explicable on the basis of it referring in a compendium way to a judgment which leads to an order, because I can't see how paragraph 4 is given any meaning if you don't take that view. So here what we've got is we've got the judgment of Mr. Justice Andrew Smith, which has led to an order that this claim is dismissed. Until such time as there is permission to appeal and a successful appeal, I appreciate that leaves the stay in place, but until such time as there are both of those two things in SCAT's favour, if they occur at all, then this claim is dismissed, and paragraph 4 dictates, mandates, predetermines that the DIFC is going to treat it in the same way. It doesn't matter whether the DIFC thinks it I say with respect, believes it's got a revenue rule. It's because both parties have taken their chances on what is going to happen if the matter is ported over to England. In other words, the case was to be dealt with in England. The search and seize order was to be managed by the DIFC. That's what this is all about. And the case has been managed in England. SCAT agreed expressly and explicitly to hitch the fortunes of the claims against EGDL and EPL, because it ported EPL across and we agreed that it could be joined. It's hitched the fortunes of those claims to the fortunes of the London claims. And paragraph 4 makes that absolutely without question clear.
Paragraph 4 is only really there, isn't it, for enforcement purposes, because the whole basis of this exercise was that both the DIFC Dubai defendants would be defendants in the English action. So once you've got a judgment in England, once you've got a final judgment, so to speak, final disposition, you've got a judgment against them. The only purpose of having any order left at all in the DIFC would be for enforcement, wouldn't it?
Well, rather not necessarily, because I say not necessarily. That puts I think on reflection, I don't, if I was in respect to say so, don't agree with that proposition for two reasons. One is because we know that the purpose of this, if you read the order and the agreement together, was in fact to impose on all parties an acceptance of matters of fact and law, both onshore and offshore Dubai, as being binding on them. And that's not an enforcement provision. That's an assumption built into that there might well be proceedings continuing in one or both of those different jurisdictions, and then those findings become binding. The second reason I don't agree with Your Honour that this is pure enforcement is that there is only a stay on the proceedings in the DIFC.
Yeah.
The other way this could have been managed was for the DIFC claim to have been withdrawn or discontinued on terms,
Yeah.
and an application to amend in something different in England. Now, the reason that wasn't done, I suspect, although frankly I'm busking here because I can't remember and I don't know and I don't think it matters, but I suspect the answer is because the search and seize order was still being managed by you, and therefore you still needed a vessel in which the search and seize order would sail.
Yes.
But because there is a stay, you then have to have a mechanism for dealing with the DIFC claim once you know what has happened in England. And that's not enforcement against EGDL. That is both ways. And the reason I don't agree is, if I may say so respectfully, is that paragraph 4 is not a one-way provision for enforcement. It's a two-way provision where we're entitled to follow the fortunes and they're entitled to follow the fortunes. Now, as it turns out, so far, rightly or wrongly, our fortunes have prevailed, and we are entitled to the benefit of paragraph 4. Now, also, the other reason we would be entitled to the benefit of paragraph 4 is because, for example, there may well be subsidiary costs orders, for example, relating to the search and seize order, which will not be dealt with in London because they're not actually part of what's been ported to London. And therefore, we actually need a mechanism for order to dispose of the DIFC claim, which we would say respectfully you are bound to do, or you are not currently bound to do, but you will be if we continue to prevail in London.
Yeah.
So for those reasons, while I understand entirely why Your Honour seized on the possibility of it being a one-way enforcement provision only, with respect, I don't think it is.
No, well, I saw it. What went through my mind at the time was that the whole object of this exercise was to do exactly as you put it, namely that the merits of the dispute would be decided in England, and the proceedings here would essentially continue solely for the purpose of the search and sorting out the privilege issues and so on and so forth. That's what it was about. And indeed, my recollection is that on a number of occasions I said to the parties in earlier hearings, look, this doesn't make sense to have separate proceedings here going into the merits, and the parties sensibly agreed it all ought to go into one place.
If I may say so, Your Honour's recollection is absolutely correct, and you did make it abundantly clear that you urged the parties, and in fact I think went as far as to say would expect the parties to sort out something which would resolve the double jurisdiction. Now, that in a sense takes us back to where I started, that jurisdictions were put to you, overlapping jurisdictions, multiple proceedings were put as against EGDL, were put to you on the basis not of forum shopping, but on legitimate forum shopping, or illegitimate forum shopping for that purpose. So they put to you on the basis of a concern over enforcement. Now, I'm not about to take Mr. Montague Smith on about the difficulties of enforcing in Dubai or enforcing DIFC orders onshore Dubai and vice versa. That's really not the point. But whether he was right or wrong about, whether he was right or wrong about that, I don't think is relevant for this purpose, and he may well be right. What is relevant is the basis upon which Your Honour was asked to sanction the use of these documents in 3 overlapping jurisdictions, which you would not otherwise have done, I hazard, had you believed that this exercise was a forum shop exercise rather than a legitimate and explained enforcement question. In other words, the concern was to avoid an enforcement black hole, not to forum shop. Now, that is an important distinction, because what SCAT is now saying is that it's got these parallel proceedings and it's going to be thoroughly prejudiced if it can't independently pursue them. Now, based on what Your Honour was told originally, And if I'm right, what you ought properly, or reasonably have had in your mind when you made the original orders, you never granted to SCAT the ability to seize 16 million documents, deploy them, and then continue to deploy them in any jurisdiction which happened to give them a material advantage. That is forum shopping. That is not a concern over enforcement. The continuation of the parallel proceedings onshore Dubai is not being pursued currently, or won't be pursued when the appeal, if it, as we hope, it comes to naught in London. It won't be pursued because of a concern over enforcement. It will be pursued, as Mr. Al-Hashimi has said to you, because, rightly or wrongly, because he says, SCAT says, we've done a great job here, because we can continue to pursue in onshore Dubai because there's no revenue rule. That's not an enforcement question. That is precisely the forum shopping question, which I'm saying your Honour should be alive to. And it permits them to say, well, we've had a crack in DIFC, we've moved DIFC to London, we've royally lost in London. We're now going to try and come back to the DIFC and have another go, defiant of paragraph 4. And by the way, we are entitled to carry on onshore Dubai because that gives us a material advantage. Now, the answer to that would be, if they thought onshore Dubai provided them with a material advantage, then they should have sued in onshore Dubai and not sued in England. What they can't do, I would respectfully submit, is to invite you to permit them to pursue multiple proceedings, in effect, because you did hold the purse strings, didn't you? Because the DIFC court was the one with the 16 million documents, and you had control over them. So they said, give us the 16 million documents, and we'll pursue these parallel proceedings for enforcement purposes. And you allowed them to do that. Now, I'm not questioning that. I didn't question it at the time, and it's not for me to revisit that decision that Your Honour made. But what Your Honour did not do is give them 16 million documents in order to deploy them in any jurisdiction where they happen to have a better chance of winning. That's forum shopping. And they didn't invite you to permit them to do that. You didn't permit them to do it. That's what they're now doing. And they're doing it onshore Dubai as we speak. And what they're hoping to do is to do it before you in the DIFC if they fall flat on their face on appeal in London. Because they're saying they can look at this conduct and claims agreement and the conduct and claims order, come back to the DIFC and say, tee-hee, well, we ported the claim to London and lost it, but we're going to run it again. Because under the DIFC, we can completely reinstate the DIFC claim because it gives us a material advantage. And that means that Your Honour is going to have presided over the use of 16 million documents, and I don't mean this in the least sense disrespectfully, but you will have been led to have presided over the use of 16 million documents on a multiple proceedings forum shopping basis over a number of years and millions of pounds of the cost, allowing SCAT to pick up their winnings in any jurisdiction which will permit them to do so, if there are any.
Well, Mr. Jones, there's a real difference between the DIFC and onshore Dubai. I'm speaking for myself, not having heard Mr. Montague-Smith. I'm entirely with you so far as the DIFC is concerned. But so far as onshore Dubai is concerned, I gave permission for the documents to be used in onshore Dubai, having very little idea, I confess, as to what use was going to be made of them in onshore Dubai. Rather less, I think, than I had with regard to USA and Malaysia. But at the time when I made orders right from the beginning that they could be used in both England and Wales and Dubai, I must have envisaged proceedings going on in Dubai.
Yes, but the reason for that was proceedings going on in Dubai accepted by you as legitimate because of SCAT's concerns over enforcement, not because there might be different results in different jurisdictions, and that they'd like to have the benefit of the last one left standing, because that's the effect of what they're currently going to be saying. So
what did Dubai proceed? I mean, I don't know about the onshore Dubai proceedings, do I, Mr. Jones? They weren't stayed in a similar manner to the DIFC proceedings in favour of England, were they?
no, they're not. No, they're proceeding. In fact, what's happened on onshore Dubai is that the claim against Sanjay Shah has been dismissed.
Okay.
There's an appeal, as was the claim against his wife.
Yeah.
There was an appeal against the latter, which failed, and it's possible that that's going to be the subject of a second level appeal, as I understand it.
Yeah.
Potentially, there is still an appeal live against Mr. Sanjay Shah, and in the context of that appeal, SCAT wants to continue to deploy documents they've already deployed. But Your Honour, there's an important point here. It may well be that we're going to has the horse bolted type argument towards the end of my submissions. We'll come on to that in due course. But it's
the bag was the way I was going to put it. But
well,
yeah.
that's an argument. Well, I'm going to have to address, and we'll have to come to it because I do understand the point. But not all the documents have yet been deployed. So the fact of the matter is that there is a residue of documents. I don't know what's in them. There's a residue of documents which have not been deployed. So Your Honour does have some flexibility as to what you might do. And just a word on the privilege review, because that did figure in the original application. To deal with the WFO in London, we reached agreement with SCAT that the WFO would continue, and we secured funding through to the end of July, a funding regime which satisfied us and satisfied them. That funding regime is confidential for obvious reasons because it concerns confidential assets. But as part and parcel of that, we agreed that we would continue to finish the privilege review. We also agreed to do whatever else we needed to do in relation to disclosure. And the reason we did that, even though we're spending our clients' money, is that the costs of standing down the review teams and picking them back up again in 2 to 3 years made it a bit of a nonsense to do that. So what we've agreed sensibly is that we'll get everything as far as we can, as it were, to base one, but that doesn't predetermine that the document should then be deployed. What it does is it allows the parties to pick up the threads in a year or two's time, if we're going to have to, with the most efficiency. And one of the points that Your Honour will probably will know instinctively that has concerned us is how long the London claim will take to get resolved if it's restored after a 3-year appeals phase. And therefore, what we needed to do was to be sensible and ensure that the restoration period was as efficient as possible, should we get to it. So that's why you're not being asked to say anything about the privilege review bit, because in effect, I think there's a handful of documents perhaps to finish, but I have been sent for report. But in reality, the privilege review has been resolved, I think.
Yes, no, I've understood that point, and
that I'm very grateful.
There's a distinction between what has not yet been handed over and what's already out of the bag, or
there's that distinction.
Yes.
Yeah, a point's been made by Mr. Montague.
I just want to go back to the onshore Dubai thing, because of course I've got no power for onshore Dubai.
None at all.
But at the time I gave permission for the documents to be used in England and Wales and onshore Dubai, it was envisaged that there would be substantive proceedings in both, wasn't it?
Well, there would, but for the reason on the understanding that we've addressed. The understanding we've addressed is it would be an enforcement. It was an enforcement justification.
I don't know if I'm entirely with you as to understanding what you mean by an enforcement justification. I think that what I had thought was that there would be potentially jurisdictional issues for the same reason as Elysium Properties, I think, was not a party in England, but was a party in the DIFC. I assume there would be potential problems in onshore Dubai. Obviously, it would affect enforcement at the end of the day, should any judgment be given. But I think I had always imagined that there was the potential for substantive proceedings in onshore Dubai. And I'd rather hoped, in the same way as I was encouraging the parties to take everything to England to get it resolved, that the onshore Dubai court would be saying much the same thing, with the result that everybody would go to one forum.
Well, I'm not.
I'm saying that that's what I think went through my mind at the time.
Well, I'm grateful to hear that, and I don't think it affects the submission that I'm making, because the point that was put to you, and I've taken you to the submissions that were made in June 2018. The point was put to you is that they were going to be suing Mr. Sanjay Shah in England, and if they sued Mr. Sanjay Shah in England, there may be difficulties in getting that enforced onshore Dubai. And if they were suing EGDL and the DIFC, ditto, and so on and so forth. So there were a series of interlocking enforcement questions. So the fact that there would, you ought to have in mind the possibility that there would be what you've called substantive proceedings. In other words, not an application to enforce an existing judgment.
Exactly.
I don't disagree with that at all. I entirely understand that that is the position. But the basis upon which you agreed to release the documents for that purpose was that those parallel proceedings were being pursued because of an enforcement issue, not because of a desire to forum shop and have the advantages that might occur from different forums. That's my point, and I'm sorry if I haven't made that particularly clear. I'm not suggesting when I've referred to enforcement that you didn't have in mind that there would be what we're calling substantive proceedings, in other words, a claim form, a defence, and some sort of process thereafter. But why was that process being gone through? What was the justification for it? Because you may have taken a very different view, and I would respectfully submit that you would have taken a very different view had you understood that what you were being asked to do was to release 16 million documents into different forums, so that if the claim went wrong in one forum, they could make use of them in another to their advantage. Not for enforcement purposes, but for the very substantive purposes that you've suggested. That's the distinction. And I don't need to say more about it, because in a sense, I've already said at the beginning of today, Your Honour's going to have the best recollection of, or some recollection of what you had in mind. I can't tell you what you had in mind. I can only make submissions as to what, on the face of it, I must infer from the facts, or would like to infer from the facts that Your Honour had in mind. And I would venture to submit you would not. I'm sorry, Your Honour, I spoke over you.
You finish what you're about to say, and then I'll come back to you.
Well, I venture to submit that Your Honour was not sanctioning substantive proceedings, parallel overlapping proceedings, on the basis of granting to SCAT the potential for materially different answers in each of those jurisdictions, which had nothing to do with an enforcement concern. That's the point.
I think what I would have envisaged, and I'm not sure this is genuine recollection or simply trying to think back as to how my mind is likely to have worked, I would have taken the view that there was likely to be, as I still think there is, a res judicata doctrine that operates in onshore Dubai, or something similar. I would have taken the view probably that if there was good reason to begin in onshore Dubai because of enforcement, it was then a matter for the onshore court and the English court to determine which of the two was the forum conveniens, applying appropriate principles according to their conflict of law rules, either to grant an injunction or a stay or whatever the case might be. That's what I would have imagined, and therefore what I would have hoped and expected was that the parties, one way or the other, would settle on one forum with the aid of the courts if necessary. So there was only one ultimate set of substantive proceedings, but if not, then there would be the ugly race to judgment that the authorities deprecate, and whoever gets there first wins by virtue of res judicata. And the problem, of course, arose, which I probably didn't anticipate at the time, that you could have a policy decision, so to speak, that might not be give rise to res judicata, in the other jurisdiction, because we probably didn't focus very much on the revenue law point, although I know it was in mind.
It was in mind. I think that the game changer for everybody was the fact that Mr. Justice Andrew Baker pressed very hard for the parties to line up to take it as the first of two preliminary trials. And that first emerged in January 2020 at the January 2020 CMC, when I think it's fair to say that all of us had turned up ready to debate the case management over 3 days, as it turned out, the 3-day case management of something that was thought then to last 30 or 35 weeks. What we ended up with by the time we got to July, and Mr. Justice Andrew Smith described that as the case management decision of last resort, I think. We ended up being sent away with the flea in our ear to do rather better. We all came back in July, and what emerged from July was a revenue rule trial in early 2021, a 6-week, if you like, expert-driven trial about the validity of the trading in October 2021, and a 16-month trial listed from January 23 until April 24 to crack on everything else bar remedies, which was then held over as a sort of 24-25 issue. So that puts in perspective, for you, Honour, the obvious concern about how long this is going to take if we have to bolt that all back on to the end of an appeals phase. But it is what it is. There's nothing we can do about that, but it explains why we have been materially sensible in relation to completing disclosure and privilege review. So, Your Honour, I'm going to come back in due course because I'm running a little bit out of time, but I'm going to come back in due course, I think, in about 10 minutes, and persuade you that there is a proper course which I'm going to invite you to adopt, which will then make your position clear, the DIFC's position clear. It will then leave it open for the onshore court and possibly the American court as well, I'll come on to that in a few seconds, to take their decision. But I'm very anxious that they take their decisions based not on an assumption that Your Honour remains content that any use can be made of these documents in any other jurisdiction for any purpose which materially advances the position of SCAT. Because my point about forum shopping invites you to say that wasn't the basis upon which I, at the DIFC, agreed to permit the use of documents seized in the DIFC only under the authority of the DIFC court to be used elsewhere. So, so let me just pick up where I left off. Unless Your Honour wants to stick with that position for the moment, in which case I'll try and invert some of my submissions. I'm going to pick up where I left off. Now, as you know, but I just make it clear for you, 2 appeal issues emerged following the judgment of Andrew Baker J. That is whether SCAT should be given permission on ground 1, and that's the basic correctness of the revenue rule decision, and that applies to all defendants. Yeah. And the second was on ground 2, whether the revenue rule was, to put it, I think in some shorthand, abrogated by Brussels recast.
Yeah.
And that only applies to a handful of European defendants. So he gave permission on ground 2, so that appeal is on foot, but it's, as it were, completely, with respect to, relevant to the issues before Your Honour today. Permission on ground 1 was refused on reasoned and detailed grounds, and it's ground 1 which is the extant permission to appeal, which exists in front of the Court of Appeal. Now, that permission hasn't been granted yet, unsurprisingly. Whether it's going to be considered over the summer by the single Lord Justice, I've simply no idea. And we've currently speaking, I think, no particular steer as to when that position might be resolved. So, if we're right that the fate of the DIFC claim is predetermined against SCAT unless it obtains permission on ground 1 and then vindicates that permission in a successful appeal, then that is the foundation for everything that will then follow. So, does this court have power to grant this order? Well, that comes to the proper construction of the word vary. I think I've already dealt with this along the way. Your Honour's got the point. I don't need to repeat it. I don't think.
Nope. No.
Procedural threshold change of circumstance. I don't need to deal with. But just so that you know, if you'd asked for assistance on it, I would have taken you to CPR 3.1 and the English case of Tibbles and the DIFC case of Vannin. But I don't think anything turns on this. Now, one of the things that I would invite you to bear in mind when deciding what to do about these documents is that all the claims we're concerned with were issued before SCAT mined into these documents and discovered what was there. So the English claim was issued, as you know, in June 18. The onshore proceedings were commenced on the 5th of August 18. The DIFC proceedings, oh, and by the way, given that you sanctioned the use of these documents on the basis of a concern on what you were told, namely that EGDL would be pursued in all 3 jurisdictions, may surprise you to know that EGDL is not being pursued onshore Dubai. So that's another basis for us quite rightly saying that the situation is very different from the one in which you originally sanctioned the use of the documents. Now, the DIFC proceedings we know were 2018. The particulars of claim were served in September 2018. The US proceedings were issued in October 2018.
I'm sorry, I was thinking about something else. Give me those dates again. Onshore was August 18.
August 18, the DIFC proceedings, I think, were issued either before or shortly after the ex parte in front of you. I've made a note that they were issued in February 18, but I think that must be a wrong date from me. But the point is that they were, the particulars of claim for those were served in September 18. So for my purpose, the precise starting date doesn't matter. The point I'm making clear, because the US proceedings were issued in October 18,
yeah,
was that the 16 million documents weren't even uploaded onto a usable platform until October or November 2018. So all these proceedings were conceived and got underway and pleaded before these documents were mined. So this isn't a question of coming to you and saying we need these documents to get this case underway. They already had the cases. And the question is, should they be allowed to continue to use the documents? That's the point. But it's important for Your Honour to know that very short chronology. And in none of those cases was it said that the pursuit of the claims was dependent on the disclosure from the DIFC defendant. And I've already made the point about multiple proceedings, so I'm not going to go back over that. I've dealt with it, as it were, along the way during the facts section. So I'm sorry in a sense if my submissions haven't followed my agenda for the day, but I don't think Your Lordship's going to be troubled by that. And I've made the point about forum shopping. So the question then is, what's the issue about the status of the revenue rule in the DIFC? Well, our primary case is not relevant at all because of paragraph 4. I'm not going to repeat that. SCAT then says, and I don't mean this in the least sense critically, two inconsistent things, if you like. They say the court can't deal with the revenue rule issue in the DIFC now, but if and when it does, it will be resolved in their favour. And I agree, you can't deal with it now. But bear in mind there's a distinction between dealing with the application of the revenue rule to the facts of the case, which would be a matter which is currently stayed, and deciding whether the DIFC has a revenue rule at all. And I don't see any circumstance in which you could be prohibited by the stay in the DIFC claim from, in the context of an issue, for example, were you to want to do so, in the context of a difference between the parties as to what to do with the EGDL search and seize documents, to make a threshold decision about whether the DIFC did or did not include a revenue rule, because it wouldn't be an entirely moot point. But well, I don't think it would be a moot point. I'm not inviting you to do that. I'm just making the point that Mr. Montague Smith's submissions are a bit of a blunt instrument in that. I also want you to know that if in due course we have to get to the situation where we have to debate whether the DIFC has a revenue rule and how it might apply it, that will be controversial. We do not accept that it's correct what is said by the other side. And all I wanted to do is to give you a flavour of why that might be. And in view of the time, and I think the position that I'm robustly saying it just simply doesn't matter, I'm not going to do more than this flavour. So one of the three cases I'm going to mention is one that Your Honour was the judge in, so you'll remember the point entirely, I suspect. So in your bundle, if you want to look at them, you will see in the authorities section that there are references to DIFC law, the JAL, and Article 8, which is as Your Honour will well know, the watershed provision for civil and commercial matters.
Yeah.
Which, as you also well know, will get you down to the laws of England and Wales as number 5 in the watershed. But I'm not going to take you to that. You're fully aware of the provision. The documents, the cases, I just wanted you to note, just to note that there will be a lively debate about this. It is a case of yours called Pearl Petroleum, 2017. So a little bit earlier than this one. So 4 years ago. So your recollection may not be a very detailed one. But there's also a case called YYY against ZZZ, which is a decision of Justice Field in 2017 as well, and a case of FAL Oil, which is Justice Wayne Martin in 2019. And I'm not going to walk you through those today because I don't think it's necessary, but it's just there to say that we do not accept the proposition that we will be in any different position in due course were it to be necessary to come back and have a restored trial in the DIFC, which is only going to happen if we win all the appeal processes in London. So what SCAT is holding over the DIFC is the prospect that they lose comprehensively in London, leaving aside ground 2, because we're not interested, the DIFC is not interested in that. So when I say comprehensively, I'm talking about comprehensively in relation to ground 1. And then come back to the DIFC, lift the stay, and then say, well, Sir Jeremy, you understood that you sent us all off to London, but actually that didn't work. We're now going to come back and haunt you for the next 3 years and do it all over again. I wouldn't want you to believe that isn't going to be, all other things being equal, a significant contest.
Understood.
And I've given you those references, but I'm not going to spend your time because I'm already over my hour. I think we're still going to be okay to finish in the 4 hours, but I do need to speed up a little bit. So what are the options? Well, I've already suggested that I'm not persuaded that the stay in the COC order would prevent the court from considering the question of revenue rule, but there it is. I won't go further into that. I'm not going to repeat what I've said about the basis of the original application, but I would invite you to agree with me that not only should you assume that Justice Andrew Baker was correct for this purpose in saying that so far as he's concerned, the search and seizure order was obtained on a false premise. Insofar as it was extracted from the DIFC court on the basis that those documents would be used in London, as Justice Andrew Baker is without question correct, they were extracted on a false premise. And Your Honour must have believed that there was a legitimate private law claim in England at that stage for you to have sanctioned, I suspect, the use of those documents. So when it's said by SCAT that the false premise point made by Mr. Justice Andrew Baker in London, which is paragraph 18 of the consequences judgment, doesn't apply in the DIFC. I think with respect, he's wrong about that, because you did order the seizure of the documents and sanctioned right at the start their use in England, and you could only have done that because you've been persuaded, entirely honestly, of course, persuaded by SKAT that they had legitimate private law claims in England to bring. Well, it turns out that they didn't, as matters presently stand. So that is properly described as a false premise. Yeah. Let me just say this, because we do have quite a number of people logged in to this game, this application, and it is newsworthy in some countries, as you can well imagine, which is clear. It's newsworthy status. I'm not using the word false premise in any sense pejoratively. You know I'm not, but forgive me for saying so openly, just in case I'm misrepresented or misunderstood. I've got no doubt that whatever was put to you with the utmost good faith, but that doesn't mean to say it wasn't a false premise, objectively considered. So the second, I would say, false premise, but I've already dealt with this, I'm not going to repeat it. The second false premise is that there were only going to be multiple overlapping proceedings, which you otherwise would not have agreed to for enforcement purposes. Now, let me explain what I mean by that. It wasn't for you, I suspect, to dictate to SKAT whether it tried to issue proceedings in other jurisdictions. But my point is that had you understood that their overlapping proceedings were in fact for forum shopping purposes, I venture to submit that you would not have sanctioned the use of the documents in other jurisdictions. That's my point. It's not that you had complete control over what other proceedings were issued, because as you would rightly say, you've got no control over Dubai, no control over England, and there might well be a race from time to time. The question here is whether you would have sanctioned the use of the documents in the circumstances that have now turned out to have happened. In other words, the false circumstances, rather than the circumstances which you were led to believe, which was that the overlap was for enforcement reasons, not for forum shopping reasons. So let me now come to my section 4, which is issue of discretion. And let me just in, I hope, 5 or 10 minutes maximum, so sometime between now and the half past the hour, I hope to wrap this up, subject to your honours having further questions. So the question of prejudice needs to be considered, because that's said by SKAT to be so clearly in their favour that your honour should throw us out if we're right about everything else. But the question of prejudice in relation to the onshore proceedings is blindingly obvious. There wouldn't necessarily, obviously, normally be a disclosure process onshore Dubai. If there was, it wouldn't involve handing over 16 million 16 million of documents. EGDL's UBO has so far successfully defended onshore, but is the subject of an appeal by SKAT, and SKAT is trying to win that appeal by reference to the seized documents. I've made the point that it didn't need those documents to initiate the claim. So SKAT is, with the greatest respect, therefore seeking to profit against EGDL's UBO from the documents it should never have received. It is not doing so for enforcement reasons, but for forum shopping reasons. That's what I invite you to find. If the claim onshore Dubai against the UBO succeeds, it will deprive EGDL of all assets, everything. That will be the consequence of it. And that is plain and obvious prejudice. Now, EGDL is not a party to that claim. It doesn't have jurisdiction to go to onshore Dubai and make submissions. But and it is the only party before you for this purpose. But it's the documents from whom the party from whom the documents were seized was EGDL, and that party is plainly going to be prejudiced. Secondly, we do not.
Is ELYSIUM Properties party to the onshore Dubai proceedings?
No.
It's just the Shahs, basically. The Shahs, yeah. And the four employees.
Yeah. So EGDL was in England EP was ported to England as part of the transfer deal. So we do not know currently what view the Dubai court will itself wish to take about the use of the documents in the circumstances which have now arisen. And I'm not inviting your lordship to try and double guess what they will do and what they will say. Now, I strongly submit that the onshore court is likely to be assisted by the view of Your Honour's court about this change in circumstance. And what I'm particularly concerned about, and I invite Your Honour to keep firmly in mind, is I have no doubt of any kind whatsoever that whether we're in onshore Dubai or in the US, SCAT will say to those courts, if they prevail before you today, that this court is perfectly happy for the onshore court of the US court to continue to review the seized documents, etc., etc. That is what they are bound to say, because that's what I would say in their circumstance. So I don't wish this to sound in any sense in terrorem, but Your Honour, in a sense, has a responsibility. That sounds rather rude to me, but you'll know why I say that. To make the DIFC's position clear, even when, in making it clear, you accept, as you would no doubt wish to do in a reasoned judgment, that you are not purporting to influence a foreign court or double guess what it should do or might want to do. But I'm inviting you to say that in the circumstances that have happened, while the stay remains, we know from paragraph 4 that the DIFC claim will completely fall away, if we're right, if that appeal fails. What SCAT wants to do is to use the time during which the appeal is on foot in England, if it ever gets on foot, in order to shore up their positions in onshore Dubai, America, and possibly Malaysia. That's what they want to do. Now, I don't blame them for wanting to do that. I'm not being pejorative, because if I were they, that's exactly what I would want to do. But they're using documents that you allowed them to use for a different purpose on a different basis when the facts were different. That's the point. Now, we're not asking you to discharge the order. That would have to be wrong. We think that would have to be wrong because you can't make a decision, and I'm not asking you to, that the application to permission is bound to fail, permission to appeal. It's just one of the things that may occur. So it is not impossible, as we sit here today, that there will the stay will continue and the claim in England will be restored and go on its merry way, in which event the arguments we're having today will fall away. The question is whether SCAT should be materially advantaged by your court doing nothing in the meantime. And I say only this, that it was a surprise to me, given the parallel proceedings, the use of the documents, and the determined use of those documents in other jurisdictions, whilst the stay position is being resolved by the appeal process. It was a surprise to me that at no stage has SCAT sought from the English Court of Appeal an expedited appeal process. It hasn't sought one. It hasn't sought a leapfrog, and it hasn't sought an expedited appeal. So this is going to proceed on in its normal merry way, with this case, regardless of its size, taking its place in the queue, which generally speaking is not insubstantial in English appeal processes, as your Honour knows. And I'm not saying that they've deliberately not applied for expedition for this reason. I don't have to say that. It's a fact that they haven't. It's a fact that the appeal will proceed on its merry way in the queue. And it's a fact that SCAT wishes to make use of these documents in the meantime to advantage itself materially to EGDL's obvious prejudice and the prejudice of its UBO in other jurisdictions. And I would venture to submit that the onshore court, what the onshore court does following today will obviously be up to it. So I'm not inviting Your Honour, obviously, to try and influence that court or predetermine it. But what I'm also saying is that that court is likely to be assisted by the DIFC's view about what should happen or what it wants SCAT to do. And that's why we framed what we've framed our application as we have. If the court thought, for example, that there could be a clash of jurisdiction which causes SCAT difficulty, in other words, you grant the relief we've sought, the onshore court says, well, we couldn't care less what the DIFC says, we want to continue looking at the documents. What does SCAT then do about that? Is there a practical solution for them to ask the onshore court not to consider the documents? Well, there should be. But what if the onshore court declines and says, well, we'll look at them anyway? Well, if your honour's worried about that, then you can put in a liberty to apply so that if there is a clash which needs to be resolved or further consideration given to further facts, the matter can come back to you. But what you should be doing today is making clear that the documents which have been seized, searched and deployed so far, in the obvious change of circumstance, with the obvious falsity, objective falsity of the premises on which that search and seize material was deployed otherwise than in the DIFC, we invite Your Honour to say that our relief is entirely proper. It doesn't seriously prejudice SCAT. If SCAT has to go to the onshore court or the US court and ask for a delay while the appeal situation is sorted out in England, and then go to the English Court of Appeal and ask the Court of Appeal to expedite it so as not to inconvenience foreign courts, and there is no evidence before you that that process could not be done. And therefore, all the interim points made by SCAT in its skeleton argument all fall away. When it says it's going to be massively prejudiced, what it actually means is it's going to be deprived of the forum shopping opportunity that it should never have had in the first place. That's what it means. That's its prejudice. Its prejudice is that it won't have the advantage of documents that it shouldn't have had in foreign jurisdictions. So that brings me on to the US proceedings. EGDL is not a defendant there. In fact, none of my clients are defendants in the US or Malaysia. Now, SCAT said to you that the US court has rejected the revenue rule defense in its jurisdiction. There are 3 points you need to know in answer to that. First, it did not reject it absolutely. It left open the door for a rematch, a further application. And you get that from page 833 in your bundle. That is the judgment. Your Honour can look it up now if you wish, but I don't want to take time on it. But it's quite clear from page 833, which is the Judge Kaplan's judgment in the New York District Court, that he said no, but he wouldn't rule out the possibility that as the case unfolded, the matter could come back to him to be reconsidered. Secondly, we know that the issue remains live in the US because we now have what's called a joint report. And Your Honour will find that, and I will take you to it, please. It's in Case Lines Bundle I2, and Your Honour has it starting at page 2212. So I'm sorry to take you to the first page. There's nothing there of any relevance, but at least yes, you can see the nature of the document that I'm asking you to take account of. The first thing you will note when the page comes up on the screen is that it's dated July the 29th, 2021. So this is hot off the press. And it's a report to the court because of the size of the litigation, very, very much as we were all doing in London, to giving reports to Mr. Justice Andrew Baker. So the pages Your Honour needs to look at are 2221, 2222, and 2223. So if Your Honour is there, 2221 to start with I'm only just going to ask you to read quickly to yourself, please, the second paragraph under the heading Defendant's Proposal for Completion of Discovery, beginning Defendants Propose.
Yes, how far do you want me to read?
Just that one paragraph, Ron.
Yes.
If you've done that, could you scroll down, please, to the next page, 2222, and could you read the paragraph at the foot of 2222 and over the page and right at the very top of 2223?
Yes.
So, Ron, thank you. So the position is we can't assume that the revenue rule isn't going to go back before Judge Kaplan in America. In fact, it looks very much as if it is. Secondly, what he allows to happen in America in relation to the use of these documents in the meantime is an open question on the joint report to him. And given that it's dated the 29th of July, we do not, of course, as of today, know Judge Kaplan's provisional or considered response. So I come back to a point I've made in relation to the relationship between the DIFC and onshore Dubai. I respectfully venture to submit that the American court and the American parties ought also to have the benefit of Your Honour's view about what the DIFC thinks about the continued use of these documents. That's not you predetermining what the American court might think, but it's if you agree with SCAT today, all the other courts are going to assume that you are content. The DIFC, I'm sorry, I'm personalising it, so do forgive me. The DIFC is content that the documents proceed and there isn't an issue. Now, if that's your view, then that's your view, and I will have to respect it. Obviously, I will, but my submission is that is not the view you should come to, and if that's the view you come to, then it seems to me it's right for the DIFC to declare what it thinks is the right answer, and then leave the foreign courts to take their view as to what they think is the right answer, with a liberty to apply provision in the event that it needs to come back to you for further tweaking, resolution, nuancing, refinement based on whatever facts then emerge. But the simple point here is that the documents which we're talking about, if we're right, would not have been used in the US if the current circumstances had been known. And Ron, let's just deal with that very briefly, if we may. We've given you a couple of authorities in our skeleton argument, which I've not gone over because they're going to be bread and butter to you, I suspect, in relation to the high threshold for a search and seize order and the high threshold needed for an application to a court for permission to use documents in aid of foreign proceedings. This was never an application to you for documents to use in aid of foreign proceedings. This was an application to you to get documents from a defendant before you and tacked onto it a collateral use application. There is no way, I would venture to submit, you would have permitted an application for documents to be used in aid of foreign proceedings when that application simply consisted of, can I seize these offices, raid these offices, seize however many million documents there are, and I will work through them and choose which documents I wish to use elsewhere. That is not the basis upon which I venture to submit either an English court or a DIFC judge would permit an ordinary, conventional, properly justified application to proceed if you wanted permission to use documents in aid of foreign proceedings. This is a collateral use application, a relaxation of the undertaking tacked onto a search and seize order against EGDL, which was at that stage believed to be justified, but which we now know was not. Very different position. Very finally, I've got not a lot to say about Malaysia, because the documents haven't been utilised in Malaysia. Now, SCAT says, well, that may change, and we'd like to utilise them very quickly if it does, but that seems to be in a very weak position. That they're obviously not going to suffer any prejudice, and if at some stage there is an issue before the Malaysian court about their use, the Malaysian court too will benefit from the view of the DIFC. So I'm inviting you to agree with us, grant the application we have sought, to send a signal that it does not approve of the continued use of these documents in the changed circumstances, but making it clear, based on a comity basis, which I'm not asking you to cross any lines in relation to, that it's not the DIFC attempting to predetermine what foreign courts will do or want to do. That's for them. So that is the basis upon which we invite you to proceed. So, Your Honour, I've got a handful of points, but I think I'm going to give way to Mr. Montague-Smith at this stage, because I've had an hour and 40 minutes exactly, I think an hour and 30 minutes or so after we've done the introductions. And I'm conscious of the fact that you've only got a 4-hour slot. So unless Your Honour has any further questions of me, I am happy at this point to stand down and promise in due course that any reply will be very short.
Well, I apologise, because the length of time you've taken has undoubtedly been increased by my questions, but I always ask questions, and that's the nature of life as an advocate. But I have one or two more questions.
Certainly.
The first is looking at the form of order that you're seeking. I want to be quite clear about what you are and are not seeking. So I'm looking at the draft order that was attached to the application. And can you just take me through that?
Yes, the only change that we have signalled in correspondence is that 4 is currently a blunt instrument.
Yeah.
And the bluntness of the instrument, of course, is that if SCAT wanted to continue to pursue the onshore proceedings without using the deployed documents, then it wouldn't be for us to determine otherwise. And in fact, I wouldn't invite Your Honour to determine otherwise. In fact, you couldn't. I mean, I don't see any basis upon which, if SCAT wanted to proceed with its appeal, but without asking the experts who have been appointed to consider the deployed documents that were seized from EGDL, then that would be entirely proper for them to do. So the only variation is in relation to 4. We said we'd be happy to rest on 3, so long as 3 was understood as meaning that we wouldn't need 4 if they would elect to proceed onshore Dubai without using the seized documents. And that's we put that in correspondence. That was the long letter of the 15th of July. I'd even take you to it because I've just given you the essence of it.
Okay.
And you can forget privilege review because number 6, because that's been resolved in a different way, as a pragmatic way, as we've said. Paragraph 5 is a matter entirely for the court as to whether it needs or wishes to impose that on SCAT. But so essentially, save for removing the privilege review, both in I think paragraph number 2, section paragraph 2, and in the entirety of paragraph 6, and being prepared to modify or eliminate paragraph 4 for the reasons that I've said. But I just wanted to be understood that I'm still proceeding on the basis that I am asking you to order that they cease making use of the SSO material, so that would require them to say that, to the onshore court, that is the order of the DIFC court. Well, what do you want us to do? And that's the liberty to apply provision I've invited you to consider. So with those removals from paragraphs 2 to 7, the only additional one, of course, is which would be very straightforward, Your Honour to insert a permission to apply if you thought that was the correct way, and I've in effect invited you to do that.
I'll come back to you as necessary on that.
Certainly.
Three questions that follow. First is whether, in reality, notwithstanding the fact that you contend the court has jurisdiction and power to do what you say as a result of the terms of the search orders with liberty to apply and to vary and discharge and so on, whether in fact it's premature for me to do anything of this kind until there is a final disposition that results in a termination of the stay on the basis that the agreement of the parties endorsed in the consent order was intended to have the effect that the search provisions should apply until such time as there was final disposition. And I just want to know exactly what you say about that.
I would respectfully take issue with the last part of it,
right.
In this sense, that the search and seize order and the orders that followed it, and therefore the relaxations of permission for use of these documents, was expressly not stayed. So the premise which your Honour's asked me to comment on, in other words, the prematurity premise, is, I would respectfully submit, the wrong premise, because having, and I walked you through the order, but I don't need to take you back to it, but that the order draws a clear distinction between the stay of the claim, because the claim is ported to England, and your continued control over the search and seize orders, which expressly permit applications to vary under the conduct of claims order and agreement itself, but also they expressly permit an application to discharge, because the relevant order. Perhaps I ought to take your Honour back to it just very quickly. So it's the what we've got as paragraph 1356, I think it was at. So the position here is that there are three carve-outs which have remained absolutely and unqualifiedly, unconditionally with you under paragraph 2. The previous orders remain in full force and effect. Now, my interpretation of that must include paragraph 25 remains in full force and effect.
I understand that.
And the second paragraph, B, is that we can apply to vary, and we must be able to apply to vary in circumstances where your Honour has power to vary.
Right.
And C is, in a sense, consequential on A and B, so I needn't worry about C. So my point about prematurity is in two parts, therefore. The first is, I respectfully don't agree with the proposition that the agreement of the parties was that the search and seize order should effectively remain stayed and in place until such time as the resolution of the stay.
No, I understand that.
So as a matter of construction, that's not the position. So if but your Honour may still address this as a matter of discretion, if you like, balancing, a balancing process.
Yes.
And the question there is, I've already dealt with that, although I didn't introduce it in that way with that heading. I've dealt with that by saying, at the moment, this claim is dismissed. Yeah. And therefore, at the moment, it's a question of time before the stay comes off.
Yes.
Now that may change, and I accept it may change. But the question is, who suffers the greater damage in the meantime?
Yes.
Go
on.
Well, what I've made the position. We would say we are suffering the greater damage. The balance here is for you to inhibit the use of these documents insofar as you are able. You send the DIFC signal, which is our preferred order. Other courts will do what they need to do. SCAT will do what it needs to do. It can come back to you to try and refine it if that's necessary. But it doesn't mean to say in the long run that SCAT's position is completely traduced, because if they win the appeal and they persuade other courts to allow them to stand the claim down until it's resolved, they can then ask the English court to expedite, get it all resolved quickly. If they're right, the point falls away. If they're wrong, then we'll see what happens at that stage. Now, that doesn't cause them the massive prejudice they allege, but it's irreversible prejudice so far as the defendant's concerned, because EGDL is daily, every time another document is deployed, it's being put at risk of losing its assets in circumstances where it's one in London, and if we're right, and the current position advisors will win in the DIFC. It's being put at that risk because of the use of documents obtained and deployed under a DIFC claim which should never have been brought, as it turns out. So there's irreversible prejudice to us, not irreversible prejudice to SKAT, if you're looking at the balancing exercise. And if it's possible that SKAT may in due course come back to you and say, liberty to apply, we're going to suffer some irreversible prejudice tomorrow because Judge Kaplan's going to throw the claim out. Well, you could look at it based on that evidence, but you shouldn't at this stage be invited to assume that massive prejudice. When the massive prejudice is SKAT's inability to profit from the current situation. That's my balancing act point.
The second question follows from the first, in a sense, because there could be a distinction that the court could draw between the documents that have already been deployed and those that have not been deployed, and indeed a further distinction between documents that have already been handed over and those that have not been handed over. And I can indicate to you that so far as documents that have not yet been handed over, that have been the subject of the privileged SIFT that you've been doing since the Baker decision, I can see every reason why the sensible thing to do in terms of balance of prejudice is that they should stay where they are and not be handed over. But what do you say about the particular distinction of those that have already been deployed in the litigation elsewhere and those that haven't?
Well, I acknowledge right at the start that there is an obvious factual distinction,
yeah.
And there is one, and I would not want to say anything at this stage which dilutes what we hope is the power of our submission in relation to the use of all documents. But if I had to draw a distinction, I mean, this is in a situation where this is not negotiating with the court, but if I can't get everything I need, I'll have to be satisfied with what I can get. I would invite you all to say that if the documents have not yet been deployed, then they should not be.
Yeah.
And because the only reason I would venture to submit that you would draw that distinction is if the cat being out of the bag and the document being shown to third parties is something that you think is a sufficient issue to mean that you shouldn't in effect impose on SKAT the order we seek. So that distinction is really driven by what I would call the third party knowledge point, which Mr. Montague-Smith majors on, and I don't blame him for doing so. It's a factual issue which the court is obviously used to be aware of. But I just repeat the point I've made already, that I would still venture to submit strongly that what you should be doing is to sending your DIFC message to these other courts and letting them decide what they would like to do in light of it, rather than Your Honour assuming that because those documents have been seen by one or two third parties or lots of third parties, who knows what the facts really are in detail, because that's happened, you should predetermine what the defendants in the US proceedings might apply for and what the US court might then do. So in other words, this is, if you like, a comity point in some sense. I'm inviting you to take a pure decision with your DIFC blinkers on, making it very clear that you're neither assuming what another court will do, nor trying to influence what another court will do. And I think if Your Honour approaches it in that way, then you see the legitimacy of what we've asked for in the draft order. because you are remaining internationally and in comity terms entirely neutral. Anything other than that leads you into the slippery slope of, if you like, predetermining what someone else may want to do or should do. And that's the distinction I invite you to draw.
Right. And the last point I want to ask you about, which is the question of justice and injustice in using documents which reveal what actually happened. I'm conscious of your arguments about no one ever seeking a Norwich pharmacal type order, of not going through the process of seeking documents for use in foreign proceedings, and this being tacked on, as you put it, to a search order. But if one's looking at the overall position simply as a matter of justice or injustice, and that weighed with me when looking at the request for permission to use the documents against different defendants in the USA and Malaysia, what do you say about that?
Well, obviously, that depends on what claims are being made in those jurisdictions,
yeah,
which we know very little about. We know they're suing people other than us,
yeah.
but we're not parties to them. So in a sense,
As I understand it, Mr. Jones, and I think you'll forgive me if I'm simplistic about this, but as I understand it, the basis upon which they're being sued is that they made representations that they knew to be false to the taxman.
Well,
in the same way as your clients are said to have engineered a scheme that required false representations of one kind or another. I'm putting it very broadly, but that's the essence of it, isn't it?
Crudely, I understand America to be the pension end of the parties, but put simplistically, and I don't cavil with the simplicity of it. It's actually very helpful. But the point here is a question of balance, because it's definitively against us if. Well, I think what Your Honour is asking me is a different question, which is that if there was now an application properly constituted before you to use these documents solely in aid of foreign jurisdictions, and you would have all those claims put before you, you would look at them in detail, that application would be justified in detail, you may or may not take a view that that was an application which you would in whole or in part be prepared to agree. That hasn't happened. So the only lens through which we can see what you should now do is the search and seize order lens, the false premises upon which, and again I make clear, only objectively false premises upon which that search and seize order and the collateral orders were made, and a series of tacked on collateral orders, which I would venture to submit currently would stand or fall with the main order. Now, I'm not trying to create work or complexity here that is unnecessary, but it was open to SKAT to make an application, a cross application to you today, and justify these documents or the continued use of these documents on a different basis, and they haven't. I don't know what that basis would be. Your Honour doesn't know what that basis would be. We could guess, but that's not good enough. And because what we're suggesting is not definitively against SKAT, but could well prove definitive against EGDL and its UBO, both here and in America, because while he's not been third-partied in, if you'll forgive the expression, in America, there may well be circumstances in which success in the States is going to come back and bite him or EGDL and the assets thereof, even though the English and DIFC claims, and for this purpose, let's assume the onshore claim, have all collapsed. So it's definitive damage to him. It's not definitive damage to SKAT. And what you're being asked to do isn't right. It's not fair. What you're being asked to do is to assume based on facts which hadn't happened, what you might have done in different circumstances, but where SCAT hasn't even got the courage to come along and ask you to make that application now. So my challenge to them would be, if they want to make a conventional collateral use, a conventional aid of third party application, aid of third party proceedings application, let them make it. Nothing's going to happen to these documents in the meantime. The reason you gave a search and seize order is because you were persuaded that there was a risk the documents would be destroyed or lost or removed. Well, that's all gone away. These documents are wholly in the possession of SCAT. There is no risk to them. And if they want to go and discuss this with other courts, other jurisdictions, come back under liberty to apply, make a fresh application, all those things may well result in some form of compromise, in some categories of documents being used for some purpose and not others, and so on and so forth. But what Your Honour shouldn't be invited to do is just convert what you did in 2018 into a retrospectively unjustified different application, which would have been looked at very differently from the one that was made and would have required different evidence. And that's still not before you. And if there's an issue of principle, which I object to, if you like, that SCAT is taking, is that it doesn't really much matter, because these were always justified on the grounds of them being in aid of foreign proceedings and remain so. I don't think that's right. I think that defies what happened. What happened is Your Honour gave a search and seize order against EGDL on the basis that EGDL was a defendant in the DIFC, and you extended that for the reasons we've discussed, multiple proceedings in aid of blocking an enforcement black hole, to the permitted use in 2 other jurisdictions, and then was persuaded to go further, but still as a collateral use relaxation under an order which was believed otherwise to be justified. And indeed, I think I've asked you to look at the passage in your written reasons in December 2018, where you said in terms that you could only at that stage assume that the order you made was entirely valid. Well, we now know it wasn't. And therefore, the whole premise of what you did in December 18 was wrong. It doesn't mean to say that in different circumstances now, SCAT could come and ask you to do something the same or similar or a modified form, but they haven't. And therefore, that they've made their bed, they lie in it. They're asking you, in effect, to do their work for them, and that's not fair.
Just as a matter of history, Mr. Jones, at the time I made the original search and seizure order, the English court was doing the same or had done the same?
Not in relation to EGDL's documents. It had granted. Yeah, I think the only search and seize order, I think I'm right in saying, Mr. Montague Smith may know differently, but I think the only search and seize order was your one. There wasn't a search and seize order in England. I may be wrong about that in relation, but not in relation to my clients. There may be in relation to other clients. I don't know, but I can't bring it to mind, I have to say. I will, whilst I'm not talking and Mr. Montague Smith's talking, I'll see if I can get an answer to that. But there were WFO and proprietary injunction applications in London, but so far as my clients were concerned, no search and seize orders.
Right. Thank you very much, Mr. Jones. I'm sorry for so many questions.
Your Honour, not at all, and I'm sorry to Mr. Montague Smith if I've overrun my self-allotted time. Thank you.
Right, Mr. Montague Smith, where are we? Do you want to take a 5-minute break, or we don't have transcribers as such, or do you want to just bat on?
I'm happy. I'm in your hands, Your Honour. Very happy to bat on if that's your preference, but we can take a comfort break now if you prefer it. I'm in your hands.
As an old man, I could value a minute break.
I'm sure you're not alone in that.
All right, we'll take 5.
Should we say 10 past, Your Honour?
Yes, whenever you're ready, Mr. Montague Smith.
Thank you, Your Honour. I've got a little bit of sporadic background noise, so if it causes any difficulties, do let me know and I'll put a headset on. But for now, if you'll forgive me, I shall delay that moment. Your Honour has seen our, I hope, our skeleton argument.
Yeah.
That skeleton responds to my learned friend's application, and that application is rather different from what Your Honour has heard today. There are a raft of new points that are being introduced, and I will attempt to pick them up as they go along. But what I was going to do was try to preserve the structure of our submissions, which are really to take it in 3 parts, and bearing in mind that the fundamental question here for Your Honour is really what, if any, is the impact of the English decision on Your Honour's orders. And so, keeping that in mind, our starting, we have this preliminary point which my learned friend referred to, which is we say that the parties have agreed, in effect, that the search order should continue pending any appeal in England. So that is about the construction of the agreement and of the order which Your Honour has been taken to. I'll just take you back to it briefly at some point. But there are 2 parts, as Your Honour has suggested. Does that agreement permit the application which is made today? But as Your Honour says, if it doesn't prohibit it, so if this application is permitted, falls within the terms of the order, we say that the terms of the order, the scheme of the agreement, should weigh heavily on Your Honour's discretion if we come to it as to what Your Honour should do today in relation to these orders, because the scheme of the order, we say, was to preserve the status quo under the terms of the search order. But I'll develop that.
Mr. Montague-Smith, I'm essentially with you in that respect. It seems to me that was the scheme, and it would be premature, therefore, for me to go as far as Mr. Jones wants me to go. But the point I put to him about what is already deployed and what is not yet deployed seems to me to be a possible route to go in the context of what is undoubtedly a change of circumstances where, without in any way prejudging the merits of any application for permission to appeal, Mr. Jones is currently the winner.
but the winner very specifically in England.
I understand.
Yes.
But you have to meet the point, and I'm inviting you to do this if you think there are points to be made. If the decision of the Court of Appeal, if it gets that far, or there is a refusal of permission, paragraph 4 of the consent order would suggest on its face that regardless of any difference between the revenue rule as it applies in the UK and as it applies in the DIFC, a judgment would be entered in the DIFC
Yes.
in the same terms as that entered into the English courts. Now, that makes him, as he says, a predetermined winner, so to speak, in DIFC if he wins in England. And he hasn't won in England for finally, for the reasons set out in the order and the agreement and the condition for final disposition. So the point I really want you to grapple with.
I will. What you will note, though, is that there is no reference to this particular provision of the order in any of the materials that have been filed in support of this application, in my learned friend's skeleton argument. It's simply not addressed. This is a new point that he raises on the hoof in front of you today. Now, it is a point that we will need to deal with.
Mr. Montague-Smith.
I beg your pardon?
Just because it didn't surface before doesn't make it a bad point.
No, I accept that, but what that does do is constrain the way that I can actually respond to you on it. But I will give you an outline of what we would say, what we say in response to this point. The first is that in relation to paragraph 4, you can see it is, as Your Honour said, entirely about enforcement of orders. How do we know that? We see it from the agreement that sits behind that order in the first place. And I'll take you to this if you'd like. We can look at it now. It's page 1361.
Yes, give me the paragraphs. I've printed these off, so it's easier for me to look at them.
So the agreement is paragraph 2.5. It's page, internal page 7. So what you'll see is after the termination of the stay, referred to at paragraph 2.2, 2 things happen. One is the issue estoppel point, if I can put it like that, any and all findings of fact and law. It's not
Yeah.
quite issue estoppel, because it will depend, and you asked the question earlier, is there a difference between the parties as to what amounts to, whether or not Mr. Justice Baker's judgment amounts to a finding of law, or fact. We say he expressly says he didn't make any findings of fact, and it's not a fact finding of law. It's an assessment, a multifactorial assessment. It's one of those sorts of decisions. But in any event, that there it is. But then, and I'll come back to that in a moment. When we go down to B, then you will see why I say that you were right in your instinct that this was all about enforcement, because what it says is Elysium Dubai and Elysium Properties shall not object to, and hereby waive all rights whatsoever to object to, the entry of judgment in the terms of the judgment, enforcement, and so forth. So it is all about enforcement. It's not about recognition of the judgment. And then the next point is, well, what is the judgment? And the judgment was a decision on a preliminary issue, and I can show you this in due course, which is whether or not the claim is admissible in the English courts. That's fundamentally the decision.
Yes, I understand that.
And so if one carries through the judgment to this court, the effect of that is recognition that the claim cannot be brought in the English courts, not that the claim can't be brought in the DIFC courts. And that is not some sort of technical distinction. That's absolutely fundamental to what is going on here, because what the parties were doing with this agreement and this order was, as Your Honour was suggesting, trying to ensure that the underlying fraud claims were tried in England. And what the English court has decided, we can talk about whether it's not a rule of jurisdiction, but it is not dismissing the claim on the merits in the ordinary sense. It is not saying there was no fraud or that there's a limitation issue, so this isn't determinable. It is saying that the claim for fraud is not justiciable, not admissible in England. So it has the effect, the characteristics, the result of a jurisdiction decision in that sense. So is it somehow inconsistent with the parties' agreement and the order that is founded on it, that the parties should be told in England you can't have your claim here, and for them then to look to another jurisdiction where they can have their claim? And it's at that point that Your Honour would be asked to answer the question that is raised on the pleadings, which would be, does the English revenue rule apply in the DIFC? We say it has no place. And if it does, what is Your Honour's assessment of the characterisation of this claim, and does it offend against that rule? So fundamentally, this position doesn't take it any further, we say. But step back from all of that, and this is my third point. Say I'm right. I say I'm wrong about all of this. We can't bring the claim in England. We can't bring the claim against EGPL in Dubai, in the DIFC courts, or indeed against properties. What are we left with? We're left with hundreds of claims in other jurisdictions against other parties, and in the jurisdictions which have looked at it, they have said this claim does not offend against our equivalent version of the revenue rule. So we have hundreds and hundreds of claims in those jurisdictions, very valuable claims to recover those sums from other parties. My learned friend said repeatedly, and he says it in his skeleton argument, the application for a search order was never made on the basis of an application for a Norwich Pharmacal order or for some other on some other basis in support of foreign proceedings. I'm afraid that is, as a matter of fact, simply not correct. And I'll take you to those documents. And I've raised in the ex parte hearing the position where I might need orders in support of foreign proceedings. We've raised in the application for collateral use the justification for those use on the basis of Norwich Pharmacal principles. Now, Your Honour made the decision in the first instance without deciding on which basis it was being made, but quite plainly, given that Your Honour was giving permission to use the documents in both England and in Dubai, it was in that sense an order that was made in support of foreign proceedings at that stage. There's no judgment on the ex parte order, and there was no challenge to the order, and therefore there was no judgment on a return date. As to the collateral use, it's correct. Your Honour took the simple approach and said, well, there's no challenge to the search order at this stage, and therefore it stands, and therefore is it right to give permission for collateral use? Answer, yes, quite plainly. Why? Was there a very complicated investigation of precisely what was being alleged and precisely what was in the documents? No, not at all. Your Honour made that decision on the basis that it's blindingly obvious that these documents, insofar as they're relevant, ought to be available in the other forums where they would be deployed to establish a fraud. And I'll take you to some of that evidence and show you how things have developed since, and what we will be saying, which is that the documents that we have very clearly establish that the parties making the WHT applications knew full well that they had no ownership rights in those shares. So paragraph 4 of this order can't cut across that. My own friend says, oh, well, there's no application before you for an order in support of foreign proceedings. I'm not quite sure what more he wants. What we've said in response to this application is that the order can be justified, and here are the reasons why. And we give you detailed evidence about what's going on in those other sets of proceedings. It's all set out in Mr. Cross's 8th witness statement, and I'll take you to some of that in due course. We made the application in the first instance on expressly, in both cases, for the search order and for the collateral use order, expressly on the basis, on the alternative basis that it was justified as an order in support of foreign proceedings. And so it's very hard to know what else Your Honour would need. We made it clear all throughout the evidence in response to this application that that is what we would be saying. Is the technical point, therefore, that we haven't issued a further application notice which says we want the orders that we've already got on the basis set out in the witness statements of Mr. Cross in his 8th witness statement, and also in the basis of his 3rd witness statement. It's a highly technical approach to what is ultimately a question of whether or not Your Honour is going to make the orders that my learned friend is asking you to make today, which we say would have a huge amount of disruption to complex multi-party litigation, which is currently running on the basis of the documents that Your Honour has allowed us to use. And it's quite difficult to understand exactly what it would mean for us to stop using them, because the lawyers who have seen them know what they say, and they have been deployed in those proceedings for procedural reasons. For example, to make applications for depositions. They've been put to witnesses on depositions in America. And Your Honour asks the question, before I finally finish my sort of broad overview, Your Honour asks the question, well, what about an order which says everything that's been used can carry on being used, but don't use anything else? There are a number of difficulties with that. It seems to me that the fundamental problem with the position is that it leaves the foreign courts without relevant material, and a very partial fragment of that relevant material. If there is relevant material in the residual documents, we don't know. It's absolutely random what's come out of the privilege review, because it's happening in an order which isn't dictated by relevance. The other problem is one would have to carefully craft the question of what's been deployed. And Your Honour will know that quite a lot of the documents, even if it hasn't been, for example, used in evidence in a hearing, has been by order handed over to defendants in America, and in that context, that the specific problem then, which is the 3rd point on this, is the evidence of Mr. Cross is that 10 million documents have been disclosed to the defendants in the American proceedings by order of the New York court. I can take you to that.
No, I've seen that. I've seen that. That's in his affidavit. But I regard that as deployment.
Quite.
You know, anything that's been handed over has been deployed. If it's out there in the open, given to defendants or given to the court or whatever. There were 2 potential distinctions. One was between what hasn't yet been transmitted after the sifting, and that is one possible distinction, just to hold the line, so to speak, until we see what happens in relation to permission to appear and the like. And the other possibility is the distinction between what has been deployed in the sense I've used, and what hasn't yet, that humans still have held back. And Malaysia is a very good example, isn't it, where not much has yet actually happened so far as the court is concerned in relation to the documents.
Correct, but so again, I mean, it depends on what Your Honour means by applying the order only in respect of documents that have been deployed. For example, would we be entitled then to use the documents that have been handed over or deployed in America in the Malaysian proceedings? If not, why not? They're public. So you know, it seems to me to be arbitrary to suggest that we should be entitled to use these documents, that they're out there in one place, and then say, well, actually, no, you can't now use them to tell the court what happened, to give the court the proper facts in Malaysia. And that's fundamentally what this comes down to, is the prejudice that is being asserted by my learned friends is that we, SCAT, might be in a better position to show courts around the world that they have conducted a fraud. And I'll take you to the documents why we say that they're cogent. And if you've read Mr. Cross's 8th statement, you will have seen all of that evidence as to why we say all of these documents demonstrate, or at least provide extremely strong support, even stronger than when I came before you back in 2018, that is what has happened here. So if Your Honour is willing to say, let's just leave it where it lies, then so long as it's clear that that must include the deployment in other jurisdictions, so it's a cross-jurisdictional impact using the documents which have been deployed in one jurisdiction in another, then I can see that that is much less likely to have significant impact on the proceedings in those foreign jurisdictions. However, again, I say it's likely to be arbitrary, because and it may well lead to the position that you simply have the courts being faced with highly partial accounts of what's gone on. That was, and we'll go back to it, and I'm digressing, but one of the reasons why Your Honour gave permission for collateral use was because too many of these documents have been handed over. And so what will we be left with? In America, we'll say to the other defendants, well, give us back our documents. They'll say, well, we quite like this document, so we're going to hang on to that, and we're going to use it. And nobody's suggesting that there's a mechanism by which we can get an order from the American courts ordering some non-party to these proceedings to return those documents. That nobody's even begun to suggest that. So what will the situation be? We'll be advancing our case there on the basis, if it can be done, of having rolled back our knowledge to the position we were in back in February, back in 2018, and the other parties will be in a position to cherry pick documents from the trove and say, well, actually, this point's one way and that point's the other, with the view of presenting a very partial picture to the courts. So just to come back to the summary, and then I'll just, if I may, just embark on the submissions. It is in three parts, we say. Firstly, does this work under the terms of the order that's been made and the agreement? And we'll come back to paragraph 4. Secondly, even if they can make this application, does Mr. Justice Baker's decision really have the impact in this court that this court could not hear this claim? And we say no. And there will be an argument about it, but we say no. And then the third point is, even if there are no claims here in DIFC and no claim in England, can we justify this as an application or an order made in support of foreign proceedings? We say quite clearly, Your Honour has very broad powers to do that. The points that are made in my learned friend's skeleton argument are plainly wrong, both on the facts as to what happened before, but also on the law. And so now we have this new point that's made, which is that somehow this is an exercise in forum shopping, which has never been raised before. And I will deal with that. But the overarching point of that is that it is not forum shopping to be told you can't bring your claim in one forum and then try to bring it in another forum.
Yep.
All right, Your Honour. So just dealing then with the terms of the order itself, the starting point is that this claim remains stayed. So there was originally a faint suggestion that the stay might be lifted because of the initial oral application for permission having been turned down. But now I think some ink has been wasted on that. But I don't understand that to be my learned friend's position at the moment. The application was also originally put as an application to vary the agreement. Again, ink was wasted on that, but everybody now appears to agree that the agreement cannot be varied either. And so what the defendants say is that there are two sorts of provision that permit them to make this application. The first is the provision in the consent order, which derives from the conduct of claims agreement, and secondly, they rely on the provisions in the search order itself, which are in the standard form, to the effect that any party who's affected may apply to vary or set aside the search order. So if we go to the consent order, you'll probably have it all up, but it's that for those on the line there, E27 1355 is the page. And as we know, this reflects broadly the terms of the claim, the conduct of claims agreement. Paragraph 2 is the operative bit that's relied on, and the relevant provisions are firstly until the decision, the previous orders remain in full force and effect. The parties may apply 1 to vary or supplement the previous DIFC orders, or 2 for any order in support of any civil proceedings in any other jurisdiction related to the subject matter of the English claim. Just on that, it was contemplated, as my learned friend says in his skeleton, that there might be an application to use the documents in certain other jurisdictions, Denmark being one of them, for example, but that application was not ultimately made. So what's said is that this application falls within paragraph 2b(1) of this order, as far as I understand it. So the parties may apply to vary or supplement, and because they say it's an application to vary these previous DIFC orders. And our short point is that you have to read the permission to apply to vary in light of paragraph 2a, which is that the previous orders shall remain in full force and effect. And so the parties have expressly agreed by 2a that during the state, the search order on the one hand, and secondly, the order permitting collateral use in the USA and Malaysia shall remain in full force and effect. That's the agreement that can't be gone behind. Now, there is a world of difference, we say, and I think my learned friend accepts this, between applying to discharge a search order, for example, or for applying to discharge the order permitting collateral use, and an application to vary its terms. And variation here, we say, must mean changing, making a change to the previous orders, which nevertheless causes them to, little a, remain in full force and effect. So I'll come back to that in a moment, but the consent order lists, as you can see, the previous orders, and you will see that the search order is the first one. That's at 1A1. And as I pointed out in my learned friend's submissions, that always permitted the use of the documents in Dubai and England. And that was never seriously contested. And then it's the December order, the one at little 10, 26th of December 2018 order, which gave the collateral use permission. Now, Your Honour has read, again, your reasons for giving that permission. Your Honour's point there, really, and it's paragraph 3 of that order, was, and we can go back to it if Your Honour likes, was that given that the search and freezing orders remained in place, the court had to act on the basis that they were valid and make the orders that were sought unless there were good reasons not to, the collateral orders, the collateral use orders. And Your Honour went on to explain why there were no good reasons not to make them. And I'll come back to those reasons. But for now, the point is this. There is no attack, and there could be no attack, on Your Honour's reasoning in the collateral use judgment today. So that the basis for that can't be attacked. What is now said is that as a result of what's happened in London, the search order was made on a false premise. My friend says it again, and it's that which is said to justify the orders that are being sought, which include a stay of the search order generally. So the point here is that although it's presented as a stay of the search order, this is in fact a root and branch assault on the search order itself. When you look at when you listen to the grounds that are put forward, it's an attempt to say that the whole of the search order is unsound in circumstances where the parties have agreed in terms that it should continue. And that's why we say that the application is impermissible under the terms of the order and the agreement which supports it. Because unless my learned friend is able to persuade you that there's justification for saying that the previous orders, including the search orders, should not remain in full force and effect as a result of what's happened in England, then you're back to the same position you were in when you made the collateral use order and the consequences that follow from that. So there's no argument which is available for the orders sought today which doesn't involve going back on that agreed position. More generally, stepping back from it, if you accept that a discharge of an order isn't a variation of that order, it must therefore follow that a stay of the order is not a variation of the order within either, at least within the meaning of this provision. In other words, saying that the claimant cannot or is not entitled to make use of documents that they've got in other courts cannot sensibly be described as a variation of Your Honour's order that they are entitled to make use of those orders in other courts. It's a reversal of that position. It's an order, in effect, as I say, that those previous orders don't remain in full force and effect pending appeal. So it would be a breach of the agreed position that they should. Now, one of the points that my learned friend said, made in his skeleton argument, he hasn't reprised it, but it's worth thinking about, because what he says is that he relies on the fact that the SCAT itself was contemplating seeking an application to extend the order to permit the use of the documents in other jurisdictions, as Canada, Denmark, and Germany. And so the implication of what he says there is that our concession that that was within the terms of the order somehow lends itself to a broad interpretation apply to vary. But that doesn't work because of the terms of this provision, because if you go back to 2b, you'll see there's a separate provision, 2b2. Does you want to have that? It's at 1356 for those watching, using case lines.
Yeah.
So what you want to see there is that the party's permission to apply is firstly for variation and supplementation of the previous orders, or two, separately, for an order in support of any civil proceedings in any other jurisdiction related to the subject matter. So yeah. Actually, what this point does, the fact that there is that facility and it is carved out, is it reinforces how narrow is that first provision, how narrow is and should be understood the right to vary. And the way in which the order has, that right to vary has actually been used has been to deal with the mechanics of the search order, to resolve issues that have arisen in implementing the search order. So you will have seen that in the bundle, and you may recall some of this, there were applications to use artificial intelligence, for example, to carry out the privilege review. There were applications in relation to payments under the freezing order. There were questions of resolving privilege. And that, we say, is what it was intended to do. It's also worth noting, as I've mentioned, that the defendants have repeatedly said that in this application they were seeking a variation of the conduct of claims agreement. They said that, for example, it's at page 586 of the bundle, it's D12,
586, sorry.
Yes, that's right. So you'll see that's a letter from my learned friend's solicitors in advance of this application that was made, and then you'll see at the bottom of the page, application, under the heading application to vary, refers to the High Court's decision and necessitates a change in the scope of the exception to the terms of the stay that's currently in place. In particular, it's wrong that the previous orders should all remain in full force and effect pending the outcome of your client's appeal against the Revenue Rule judgment. And then over the page on 587, second paragraph down, they say, in the circumstances, our client proposes a variation to the terms of the conduct claims agreement that at this stage is limited to placing a stay on the terms of the search order as amended. And then they go on to explain what that variation will do, and it's precisely what's being sought on this application. Indeed, in support of the application, the evidence that my learned friend produced from Mr. Waters puts it in exactly the same way. You find it at page 270 of the bundle, behind tab 11.
Paragraph?
Paragraph 3 is the first bit. I make this statement in support of the DIFC defendant's application for a variation of the consent order dated 2019 as varied pursuant to paragraph 2b, and then at paragraph 26, well, under the heading variation of the conducts of claims agreement, this is on page 274, it describes seeking a variation in the terms now pursued in this application. And then you see at paragraph, and that continues paragraph 26 and the beginning of 27, and then at paragraph 31, you'll see what's being said is that in effect the DIFC court has jurisdiction to vary, come what may, regardless of what the parties have agreed, and that's not a point that's pressed today. So we say that it's relevant that is how the agreement was understood by the parties. It's relevant generally. It's relevant as a matter of law because we're in the DIFC, and as Your Honour knows, the parties' understanding and the parties' actions on the basis of the agreement are necessary things that need to be taken into account in understanding what it means. But it is telling that is how it was put, and it is consistent with what is really going on here, which is that the permission is being sought from Your Honour to in effect resile from the agreement that the search order and the collateral use order should remain in effect pending the appeal in England. I do say that there is no material change in circumstances. I don't say that there is no material change in circumstances since the first search order was made. I do say that there is no material change in circumstances since the consent order is made. Why do I say that? Because the agreement and the order expressly envisaged that there would be a judgment and an appeal in London and provided for what would happen during the course of the appeal. And so the fact of a judgment in London, one way or the other, in one direction or the other, was contemplated at all times. And so that, we say, can't amount to a change of circumstances. It was always anticipated. And that applies to both grounds on which are advanced in support of this.
It's a change in circumstances, but not a material one.
Correct. Yeah, of course, but that's the important question. There's always a change in circumstances, but whether those matter is the issue.
Yeah.
And that cuts across both points that they make, because they don't just rely on 2B now. They also take this new point raised in the skeleton, which is that they can apply under the general permission that's granted in the search orders. And of course, once the search orders are in effect renewed, as they are in the consent order, then the same point arises. The question is what's contemplated as at that date. The other answers to the second part of it, though, is that the parties agreed by the conduct of claims agreement and by the order that records it that the orders shall remain in effect, and that cuts across any general permissions that there were previously. So my learned friend says, well, the original orders include the right to set aside the search order, for example. So he has that right if he needs it. But if that is right, then paragraph 2A is completely denuded of effect, because the parties are really not agreeing to anything when they say that the search order shall remain in force, full force and effect until the outcome of the appeal. If what that means is actually it just continues, then what is the purpose of 2A at all? It doesn't do anything. So in order to actually give that any force, one has to understand that as cutting across any other pre-existing permissions that there might have been to make applications. And I'd say it's not in unusual language. So if one actually looks at the permission that is relied on to make this sort of application, so if we go to 1287 of the bundle, which is the original search order, and it's paragraph 25 of that.
Yeah.
So you'll see that paragraph 25 refers to anyone served with or notified of this order may apply to the court at any time to vary or discharge this order. So clearly, the permission to discharge, when it says this order, it is about the substance of the order. It's not saying you can just apply to discharge paragraph 25 of this order, because that would be self-effacing. And so the language that we have in the consent order is not particularly surprising when it says that the order shall remain in full force and effect. There was no, if one thinks about what was that intended to achieve, there was no extant application to set aside the search order. The search order wasn't about when they said that it shall remain in full force and effect. They were changing the position. And there's nothing surprising, we would say, about this machinery. The parties were here agreeing in effect to maintain the status quo until all the appeals were exhausted. So they agreed that issues of fact and law would be binding once the stay was lifted, which was going to be after the appeal. And only then would the defences be resolved in the DIC proceedings. So that's wholly contrary, we say, to what's going on here. What's being said is that some events before the appeals have been exhausted gives the opportunity to come back before this court and say, well, all those rights you gave us need to be reassessed ab initio. And you have to ask yourself the question, would I issue a search order now in relation to those documents, with all the consequences that that would have in other jurisdictions, including in England. So amongst the application that's being made here, as part of the application that's being made here, what is being sought is an order refusing us permission, withdrawing permission from SCAT to use the documents in England. So in other words, in effect, where the appeal is going on, we would presumably then have to amend our pleadings back to the state that they were in prior to the amendments that were introduced to incorporate the information provided in England, and try and have the Court of Appeal determine the case on that basis, in effect drawing up the drawbridge, having achieved what they say they've achieved so far in England.
Well, Mr. Montague-Smith, I don't need any persuading of that in the context of the cat out of the bag. The only question is how much cat is out of the bag, which is the sort of distinction I was drawing your attention to earlier. Potential distinctions.
Yes, as I understand it,
blindingly obvious that you can't rejig the English proceedings until such time as decisions have been, the Court of Appeal has to deal with the material it currently has.
That's the application that's made, to Your Honour.
Well, I understand that, and I don't think Mr. Jones was seriously pursuing that. It's a circular argument, isn't it, to say that the before the Court of Appeals decided whether or not Mr. Justice Andrew Baker was arguably right or wrong, the material upon which he decided should be withdrawn from the court. I mean, it can't be right.
In which case, I don't need to trouble you with the consequences of the order that's sought if it's confined in that way on the English proceedings. But that has been a live concern for my clients.
It's not a point that Mr. Jones pursued orally, and one can see why not.
I see. So, well, he's shaking his head, so I understand he's not pursuing it. And in terms of cat out of bag, and we'll come back to this, what's happened in England, as I understand it, is that 955,000 documents have been disclosed pursuant to disclosure. Much of it has been disclosed to, as I understand it, the Shah defendants, so my learned friend's own clients. So
yeah.
And they'll have that anyway. I think 154,000 documents or thereabouts have been disclosed to all of the defendants. So there's a lot of material out there. Yeah. It's likely to be central. I mean, if the complaint is, well, I can't give you chapter and verse today about precisely what is in the hands of whom, that is obviously going to be a very significant undertaking to understand precisely what's in that documentation. And it doesn't seem to me that it is necessary for Your Honour to have that degree of detail in order to determine this application. All right, Your Honour, I wasn't going to say much more about the bare question of whether they're entitled to make this application. But clearly, I have in mind Your Honour's point, which I agree with, that even if you accept that there is this carve out that could be deployed on a construction to make this application, then it should affect Your Honour's discretion. It should weigh heavily in the exercise of discretion. As my learned friend
I think it goes wider than that, as I was indicating to Mr. Jones. Whether or not you're right as a matter of literal construction, the whole tenor of the agreement, in a sense, requires the scheme to remain in place until final disposition of the matter in England, and that's the way I've always understood this.
Yes,
and it's the way I see it now, even having heard all the arguments from both sides on it.
Well, that's my fundamental proposition. So it goes beyond the discretion point. It does weigh on discretion, but I just leave you with this one further point on this. My learned friend accepts that everybody anticipated that in England this was something that was going to head off for a 6-month trial or thereabouts or more. I think he said 32 weeks, which is not something that anyone expected to happen by now. It was going to be years in the making.
Yeah. So
if one looks at where the parties were when they agreed to all of this, they knew full well that that English proceedings would take a long time, and that you wouldn't get any kind of judgment out of the English courts for a very long time. And in that time, those documents would be used, as Your Honour had permitted, in Dubai, in Singapore, and in the USA. So if one looks at it from that perspective, perhaps not the strict interpretation of the agreement, is what you're being asked to do today within the tenor, within the thrust, within the gist of what was being agreed. That on the basis that there's some preliminary issue saying we can't do this in England, let's all go back to do DIFC and tear up the orders while the appeal's going on. It's absolutely not. It's absolutely not what was contemplated by the parties. That's all I was going to say on that issue. I was going to move on then to the question of the effect of the English decision on the substantive DIFC proceedings, because of course, so I assume I'm wrong, albeit it will affect your discretion, but assume I'm wrong on that, and that the application is open to the defendants and should really be we should be starting again in effect on this. The next point is that the effect of the English decision is not, as my learned friend has suggested, to prevent a claim either here or in any other jurisdiction, because there are substantive claims here which were going to fall in line. I'll come back to his paragraph 4 point in a moment, but there are substantive claims here which were to fall in line on facts and law with the English judgment. And there are two parts to this. So first, looking at, as I say, the substantive claim advanced in this jurisdiction, the DIFC, and then second, looking at our third point, our last point, which is looking at the search order as a disclosure mechanism in support of foreign proceedings or of other proceedings, so as not to call the Dubai court proceedings foreign. So it's here that we say, at least in the written submissions, although the oral submissions are very different, that the defendants, we say, fundamentally misunderstand the effect of the judgment in England. So, because what they fail to do is distinguish between the lex fori and the lex causae. So to put it in plain English, the decision of Mr. Justice Baker was not that the claim by SCAT is inadmissible anywhere. It is that the claim is inadmissible in England.
Yes, well, I don't need to be taken to the relevant paragraphs of the judgment on that.
I'm grateful. So when my learned friend says, though, for example, and he says this in paragraph 38 of his skeleton argument, that the result of the English judgment, he says, is that SCAT has no claim against these defendants under English law, that is not an accurate summary of what the position is. So that's central to his argument, at least in his skeleton. He says all of these claims are governed by English law, even in the DIFC courts. And paragraph 38, by reason of the above, SCAT does not have a strong prima facie claim against DDGL. On the contrary, it has no claim against these defendants under English law. The accurate...
Why did Mr. Justice Andrew Baker not like the expression non-justiciable in England? He said he used preferred not admissible.
I don't think he expressed a completely clear, a terribly firm conclusion on it. He said he preferred, I think,
yes,
those words admissible. I don't know. I'm afraid perhaps my own friend can enlighten you a little. I'm not sure it makes an awful lot of difference. But basically, one hears the word admissible often in arbitration context, where it's said, well, the arbitrators have jurisdiction, but the claim is somehow not admissible. It's not well-travelled field, but I think what he is making I don't know actually what the distinction would be between the two, but essentially what he's saying is that he's not going to decide the claim.
Yes, I mean it's the same principle that underlies the Act of State doctrine and so on and so forth, that you simply don't get into the business of the activities of foreign states, and they can't enforce their own revenue laws or other sovereign acts, so to speak, in your territorial jurisdiction. I mean, yeah. I've always thought non-justiciable was the right sort of expression for this, for tax laws, penal laws, and so on and so forth.
My own view is literally that's right. That's not clearly the language he preferred. I don't discern too much difference in his thinking flowing from that, if I can put it like that. I mean, we can look at that passage if you like. I think it's paragraph.
No, I don't need to look at it. I was just curious as to quite why he expressed it in the way he did. But what he doesn't say is that it's a matter of English domestic law, so to speak. It's a question of, I'm sorry, I've expressed that wrongly. What he says is we can't decide this claim, full stop.
Yes, and he says that that flows because, as a matter of the lex fori,
yes,
that is a rule, not because the party's rights are governed by English law, but because if you bring a claim to the English courts will apply this mandatory rule.
Yes.
To the claim. It's a supervening and overarching question of whether the court's going to grapple with it at all. And he makes clear in his judgment, as we point out, paragraph 147 of his judgment, but we've cited it.
Yeah.
That rule applies. Doesn't matter whether or not the substantive claim is governed by Danish law. So Your Honour will perhaps have noticed that in this court, the claimant's position is that the claim is governed by English law, but in the alternative, by Danish law.
Yeah.
What's being said is, well, because you said that it's governed by English law, that means that English law applies. and it applies even to this issue.
Yep.
So if we brought a freestanding claim, forget about the conducts of claims agreements and all the rest. If we brought a freestanding claim for these frauds in the DIFC and said that claim is governed by English law, my learned friend's position, on his skeleton at least, is that the English revenue rule would apply and does apply, not as a matter of because DIFC law falls into line with English law, but just because it comes with the English law claim. That's what he says in his skeleton, and that's what we say is fundamentally wrong. It misunderstands the distinction, because obviously if one takes it to the extreme, the English courts obviously not say that the claim cannot be pursued in Denmark. So it's not a finding of that sort, saying, well, this is an English law claim and it can't be pursued because English law says it can't. And so just as obvious, we say, the English court's not deciding whether or not the claim can be determined in this court. Quite obviously. It's got nothing to say about that. And if it tries to say, if Mr. Justice Baker wants to say something about that, then he's giving a view on DIFC law, which is not something that this court should pay attention to. And it's not the way it was argued. So my learned friend relies on some observations that Mr. Justice Baker made as to the basis on which the search order was obtained. And he says, oh, well, Mr. Justice Baker found that it was obtained on a false premise. That's not actually what he says. He says, so far as I am concerned, so far as the English court is concerned, it would be a false premise. He can't go further than that. He can't say this is not a claim that's justiciable in the DIFC. And just as clearly, he can't say whether it would be justiciable in Dubai, Malaysia, or the USA. And if you want anything further about that, and this goes to the question really of paragraph 4 of the order as well. What is the decision that was being made there? And one sees it, it's recited in my learned friend's skeleton argument, paragraph 29, the preliminary issue that was actually being determined.
Paragraph 29?
29, correct.
Yeah.
Are any of SKAT's claims as alleged admissible in this court under the rule, inadmissible, sorry, in this court under the rule of law stated? So I don't know whether I need to trouble you with it, but my learned friend relies on our pleading that English law applies. Now, that was before the revenue rule was ever raised in this forum, and it was clearly understood to be a pleading based on the substance of the claims. It's about the substance, not about any aspect of the lex fori. And you can also see that from the position taken by the defendants. And I might show you that very briefly, if I may. It's on page 65. If we start on page 65, sorry, it's A3 for those using case lines. And if we look at paragraph 20, you'll see jurisdiction and proper law.
Yeah.
Paragraph 20, SKAT alleges that as a matter of Danish law, no WHT refund was due in respect of the WHT applications, and then says, so it characterizes the issue as one of Danish tax law. And then paragraph 21, this is where they plead out the revenue rule in the DIFC. The claim is therefore an attempt by SKAT to seek payment of Danish tax monies in accordance with its own revenue, custom, or administrative law. As such, the DIFC court has no jurisdiction to consider the claim. Now, the word jurisdiction mirrors what's said in the revenue rule. I think that the defendants now accept, indeed assert, that it is not a rule of jurisdiction, it's something different. But clearly what is not being said at this stage is that English law or Danish law should determine that issue. They're not saying an English law of jurisdiction should apply in this case. They're saying, and they can only be properly interpreted as saying, that as a matter of DIFC law, this is not a claim that can be advanced.
Yeah.
And at 95, they plead out Danish law applies. But in any event, so if a point is still taken that somehow, because we've pleaded that English law applies to the claim, that includes some acceptance that the English revenue rule applies to this claim here, that is simply mischaracterizing what the state of the pleadings are, because as you can see, they're saying Danish law applies to the dispute, but the revenue rule operates as a rule of jurisdiction, which could only ever be DISC law. So the result of that is that there could be no effect on the merits of the claim in the DIFC as a result of an English judgment. This is I'm talking here now in terms of the broad principles, and we'll see whether it changes as a result of the conduct of claims agreement. But if one asks the question, could an issue estoppel arise in England along these lines, the answer has to be no, because the only issue that is being determined is about admissibility in England. There is, though, a wider point to be made about this, and it arose in the case, you're probably aware of it, the UCOS Capital case, which was about the enforcement of a very large arbitration award. You've got it in the authorities bundle. It's towards the back end, so it might take you a little time to get there. So I'll give you the page number, and we can wait. It's page 1904. And for those using case lines, it's H. I believe it's tab. Got the wrong numbers. Tab 20. So it's H20 1904, and the passage I want to show you is at page 1963. Just while you're getting it, for context, this was there was a $400 million arbitration award, and it was made in Russia and set aside in Russia by the Russian courts. And then enforcement was sought in the Dutch courts, and they refused to recognize the Russian judgment on grounds of public policy.
Yeah.
And then the question arose, when enforcement was then sought in England, whether or not that issue in Holland was determinative of the action in England.
Yeah.
And so if you look, please, it's page, as I say, 1963. Tab it up. And it's paragraph 151. So the difficulty with Mr. Pollock's submission is that public order or public policy is inevitably different in each country. The standards by which any particular country resolves the question whether the courts of another country are partial and independent may vary considerably, and it's also a matter of high policy to determine the circumstances in which this country should recognise the judgments of a state where the interests of that very state are at stake. Normally such recognition will be given, and if it is so refused, cogent evidence of partiality and independency will be required. Our own law is, or maybe, that the considerations of comity necessitate specific examples, and so on. But it says it's our own public order which defines the framework of any assessment of this difficult question. Whether such decisions are truly to be regarded as dependent and partial in matters of English law, as matters of English law, is not the same question as whether such decisions are to be regarded as dependent and partial in the view of some other court, according to that court's notions of what is acceptable, or otherwise according to its law. And then the other relevant paragraph is paragraph 156, where there's characterization of the issue. It was put to the judge that the issue decided in Holland was that the Russian judgment could not be recognized as a matter of Dutch public order, and that was not the same issue as been decided in England. And the judge rejected that. We cannot with respect agree, because the reasons given, it makes a great deal of difference whether the issue is being determined by reference to Dutch public order or English public order, which is or may well be different. And so then they said that the issue had to go off for trial. So there are two questions that arise when you have to assess whether or not the revenue rule is infringed. The first is, what's the scope of the revenue rule? And the second is, as a matter of the lex fori, how do I characterize this claim? It doesn't matter if it's English claim, if it's Danish claim. I have to characterize it as a matter of DIFC law. I then have to determine whether and to what extent a revenue rule applies in the DIFC. That is a matter of DIFC public policy. It may be the same as England, but it may be different, and it may not exist at all. And I'll explain in broad outline why I say the latter is the right answer. But either way, there's no scope for saying that the decision in England on that issue somehow is an issue which arises in this claim. So where are we on this? What we say is, well, look, you've got the pleadings which raise the issue. You have a decision from England which doesn't have a direct impact, and could not have a direct impact on this claim. So once you accept that the revenue rule is a rule of lex fori, that's the end of it, because at the moment it's being said, well, you don't need to look at whether or not the DIFC courts have a revenue rule at all. I would agree that that's not an issue that can be decided at this point. We need full argument on it, and it's a fairly important issue. It was suggested, I think, faintly, that you might somehow be able to consider it and decide it in some way or other, but it's difficult to see how that can be right given the existence of the stay. I think all that Your Honour can do is see that there is a dispute about whether or not the revenue rule blocks the claim in the DIFC. Is that different to the position that we were in when the consent order was agreed? Well, no, because I've shown you the pleadings where all of that arose. Having said that, Your Honour doesn't need to decide the issue of whether and what is the scope of any revenue rule in the DIFC. My learned friend's told you his outline thoughts on where that comes from, and has referred you, I think, to the Pearl Petroleum case, the foul oil case, the Pearl Petroleum case and the YYY decision. The points I'd make on that were, as Your Honour may recall from the Pearl Petroleum case, the whole point of Your Honour's judgment there was that you can't just say, well, this is a common law court and therefore common law rules are imported. It doesn't follow one from the other. You decided actually in that case that although you didn't need to decide it, but your impression was that state immunity probably didn't form a part of DIFC law, but you were free. You had a free hand in determining that issue because everybody accepted that state immunity was an issue of procedure, not an issue of substantive law. And so your point was, when it comes to substantive law, we can't just make it up. We have statutes in the DIFC. You can't just say, well, it's common law, so we're going to import things. Everybody agrees that we're dealing with substantive law here. And that was the key and critical distinction in Pearl Petroleum. And indeed, there was another case called foul oil, where another judge came to a different decision and found that there was a principle of state immunity in DIFC law. But again, that was also on the premise that that was an issue of procedure. He accepts that in terms. There has been some faint suggestion that the waterfall provisions, which you'll find in Article 8 of the Law on the Application of Civil and Commercial Laws, somehow give you an avenue for importing English law into DIFC law to inform the content of DIFC law. And just to give you an outline of what I say about that, that fundamentally misunderstands the purpose of Article 8 on the civil and law on the civil and commercial laws. One has to bear in mind the distinction. On the one hand, you have conflicts of laws rules, and those allow the court to determine, in relation to any particular dispute, which system of law should be applied. In this court, it's normally fairly straightforward because the parties have chosen the particular law that applies. But there's another wholly separate set of considerations, which is if there's some sort of perceived gap in DIFC law, can DIFC law be populated with law from another jurisdiction? And sometimes people have said that Article 8 can be used for that purpose. But if and when you are interested in looking at Article 8, and no doubt we'll have an argument about it one day. I can show it to you if you'd like. No, the point is that it's quite clearly a conflicts of laws rule, because it directs you firstly to DIFC law in certain circumstances. So it would be tautologist to say DIFC law is DIFC law, and it would also imply that maybe in certain circumstances DIFC law was not DIFC law. But also it directs you to the parties' agreement, which makes sense if it's conflicts of laws, because parties can agree what law applies to their dispute. But it doesn't make sense if it's about populating DIFC law with principles, because the parties can't agree what DIFC law is, if you see what I mean. So that's the fundamental point. There were some other points that will be made, no doubt. And one of them is that, as far as anyone can discern, there is no revenue rule in the Dubai courts. And that was something which was also important when Your Honour came to consider the state immunity. So that there are real issues here about whether the rule applies. But say I lose that debate, what's the effect of that? The result is that then we will have an argument about how you characterise these proceedings as a matter of DIFC law, and then whether or not the proceedings fall within that provision, within that rule as a matter of DIFC law. And none of that can be determined by what's happened in England. And what we would say is actually, you know, if it's being said that this is completely stacked against us because what's happened in England, actually, if I'm right and Your Honour has a free hand when it comes to making those sorts of decisions, and isn't bound by the English judgment, then it is relevant to the other courts who've looked at this very claim, albeit against different defendants, have taken a very different view. And my own friend showed you what had happened in America. And he said that, in fact, in America, it's only a sort of for now decision. In fact, it's a little bit more nuanced than that, and I need to show you that if I may. And then I'll briefly show you what happened in Malaysia. If we go to page 81, it starts at 808. It's at D14 for those who have it. So the start is at 808, but if we go down to 818, if we go down to 818, we see contemplating the revenue rule as applied there. In the middle of the page, these actions plainly do not seek direct enforcement of Danish tax law. The defendants attempt to frame them as seeking to recover lost tax revenue, when the only reason the money was lost is because the defendants in effect allegedly stole it. And the only reason it was supposedly concerns tax revenue is because the defendant's alleged victim was the Danish tax authority, is too clever by half. The defendant's brief admits as much when it drastically mischaracterises the nature of the plaintiff's claims in an effort to bring them within the revenue rule. It characterised the claims seeking to recover for harms suffered as a result of the evasion of foreign sovereigns' tax laws, when in fact the plaintiff has not alleged a single instance of tax evasion. It alleges fraud, pure and simple. Defendant's mischaracterisation betrays their knowledge that tax evasion is a crucial ingredient in cases barred by the revenue rule in this circuit. So looking at the nature of the claims being advanced, you can see that a different court's taken a completely different view of this. If we go down to 821, you see on page 821, they dismiss, the judge dismisses an alternative argument that the actions seek indirect enforcement. And you see the final sentence of the next paragraph, the court disagrees. Now, my learned friend says, oh, well, but that's left open. They can come back. But you have to look at, that's not quite right. If you go down to page 831, you'll see what is left open. In the middle of the page, under the heading, the danger of meddling in foreign affairs. Second paragraph.
821?
831, please.
Oh, I'm sorry.
No, my fault. So the defendants rightly point out that rendering a decision under Danish law on question of beneficial ownership, contrary to an opinion of an administrative or judicial body in Denmark deciding the same question, would be exactly the type of harm or embarrassment against which the revenue rule is designed to protect. At this stage of the litigation and based on the present submissions, there's no reason to expect that this is likely to occur. And then over the page at 832, accordingly, this is at the bottom, accordingly, there's no indication at this point that the court potentially will render a determination with respect to Danish tax law that might conflict with a determination by an administrative or judicial body in Denmark. Absent this prospect, the revenue rule provides no ground to oust this court of jurisdiction, and the defendant's motion is denied. And this is the only window that's left open. If, however, as the proceedings continue and discovery unfolds, the prospect of inconsistent tax law determinations by this court and a Danish administrative or judicial body becomes a more tangible possibility, then it may be appropriate to revisit the issue, at which time the defendants may file an appropriate motion. So my learned friends presented it as if there's some temporary decision that the claim does not offend the revenue rule according to the American courts and that it can be revisited. But the discretion to revisit it, the window to revisit it, is extremely narrow and has nothing to do with the arguments that are being faced in this court or England. The decision also in Malaysia, we've cited it. I don't know whether I need to take you to it, but for your reference, it's pages 850 and 868. You'll find the Malaysian decision was to the same effect, that this was a fraud claim and it wasn't barred by the revenue rule. So even if this court decides that a revenue rule does apply here, there's still going to be considerable arguments about whether it applies to this claim. And as I say, in that context, Your Honours, we ask you to take on board what we say would be fairly extreme circumstances if there was to be any kind of unwinding of the use that has already been made, at the very least, of these documents. So what we say is that if this is a question, we're just going back to the beginning and saying, does the claimant have a strong prima facie case against the defendants in this jurisdiction? We say that it does. Yes, there's a defence. Yes, on one view, in another jurisdiction, they've said that they cannot hear the claim, and you might take the same approach, but there are other courts which have not. That's still a strong prima facie case. And I'll come on to where we are on the actual underlying merits in a moment. But what this doesn't do is present some sort of final closure, ending of these proceedings in this court. As I say, we now have this further point about paragraph 4 of the order, which Your Honour has seen and asked me about. I think I've said most of what I have to say about that.
Yeah,
yeah, so plainly it's about enforcement. It's not about res judicata. It's not about, was it intended that a decision in England that the claim could not be determined there should amount in this court to a decision that the claim could not be pursued here? Because that's clearly not the issue that was before the English courts. That would have to be the effect of my learned friend's submission, that somehow a judgment dismissing the claim on this ground should lead to this court dismissing the claim as well. And fundamentally, what it says is that it's the judgment that needs to be followed in this court, and the judgment is about the claim not being admissible in England. And so what we say is, look, at least where we stand at the moment, you are not in a position where that's the end of the road for us in England. But we say, even if we get to the end of the road in England, the result of it is that we won't be able to pursue the claim in England. Not that we won't be able to pursue the claim anywhere. If one thinks about the justice of that conclusion, can that possibly be fair? For the defendants to say, we agree to submit to the jurisdiction of the English courts, But here's a rule which can't be characterised as a rule of jurisdiction, even though that's how it's described in Dicey, which says that the English court won't hear the action. So they are both saying we'll submit to the English courts, but the English courts can't hear and determine the claim. And because the English court accedes to that, they come back here and they say, well, that means that the English courts can't hear and determine the claim anywhere. And that's essentially what my learned friend's forum shopping argument is. Forum shopping is about trying to select for yourself the best jurisdiction where you have the best chance of winning your case on the merits. It's not about finding out that you bring a claim in one jurisdiction, you're told that the claim cannot advance in that jurisdiction, and then you're trying again. That's just normal commercial behaviour, and it happens all the time. When this court turns parties down on the basis of jurisdiction, it's not saying there's anything wrong with them going to another forum. It's always on the basis that there's some other forum where the parties should have gone. Now, just because this isn't a strictly a rule of jurisdiction doesn't mean that the same principle should not apply. And that is why we say that paragraph 4 of this order just simply can't have the sort of meaning that my learned friend is contending for. But now assume against me that I'm wrong about that. Assume I'm completely wrong, and that actually there can't be a claim in this jurisdiction against these defendants, and there can't be a claim in England against these defendants. That, as I've said, doesn't prevent Your Honour from providing support to claims in those jurisdictions which can hear those claims. So the proceedings are, in this jurisdiction at the moment, are substantive claims against the defendants. But the search order can also clearly be justified on the basis that this court could and should have make the orders in support of foreign proceedings. And as I say, contrary to what my learned friend has told you, and contrary to the assertions of his solicitors, the application for the search order was put on that alternative basis, and the application for the collateral use orders was put on that alternative basis. That's clear from all the documents which we've provided. It's also clear in my submission from the hearings, the exchanges and hearings, which my learned friend attended, but there we are. But ultimately, the search order was continued on the express basis that there would be limited substantive proceedings in the DIFC. That was the shape of what was expected. The main proceedings against the defendants were intended, these defendants were intended to take place in England. The main proceedings against other defendants were intended to take place in the USA, Malaysia, and Dubai. That's what everyone effectively agreed to, once permission had been granted to use those documents in those jurisdictions. So the court was quite content to exercise its jurisdiction, or continue to exercise its jurisdiction in respect of those documents which had been obtained in the search, solely really for the purpose of supporting those foreign actions. So then the question is, well, what has changed since then? Only that the English court has said that it won't hear the claim, it's not admissible there. And on the premise that I'm advancing, dealing with, this would be on the premise that the DIFC courts can't hear the substantive claim either, which was never anticipated in the terms of the order that was agreed. However, even that, we say, couldn't possibly affect the claims in the other jurisdictions against other parties, whereas we've seen the court has found that the claim is admissible. That's Malaysia and the US. And the other jurisdiction is Dubai, where, as I say, there appears to be no revenue rule whatsoever, and it certainly hasn't featured in any of the proceedings before the Dubai courts. So even if the revenue rule applied here, as it does in England, even if the court took the same view that the claim infringed against that rule, that wouldn't prevent this court assisting those other courts. And there's nothing particularly wrong with doing so. The revenue rule does not block actions for documents, for evidence in support of foreign proceedings. And that was the State of Norway case. We've referred to it no points taken against me on it, I can just give you the reference. It's at page 1861, and you'll see at page 1767 an F to H. It's not an infringement of the revenue rule for the English court to exercise its jurisdiction to give assistance to a foreign state in enforcing its revenue laws. So what points are taken against us on this? Essentially, we've got 3 points, which are in my learned friend's skeleton argument at paragraph 42, and we've also got the point he makes today, which is that there's no application on foot now today for this sort of order. Dealing first then with the point that he makes, which I said is wrong, which is that there was no suggestion whatsoever that SKAT sought the search order pursuant to the Norwich Pharmacal jurisdiction. That is flatly wrong, and I better show you it. If you look, please, at bundle D14, it's page 734. You'll see the skeleton argument for the application that was made. You can see that it's for the ex parte application. So this is what Your Honour was what was put before Your Honour on that application. And then if you go down to page 749, you'll see search under heading F2, the circumstances in which a search order will be made, and then grounds for a search order, the general grounds, and then starting at paragraph 72 under the heading search orders against non-cause of action defendants. A search order may be granted against a third party to the proceedings who holds evidence that is or may be relevant to the proceedings, a Bella and a Badarani. Cause of action against the respondent is not necessary. The evidence sought may be relevant to any part of those proceedings, including enforcement, and thus the same grounds as would justify a Norwich Pharmacal or Bankers Trust order may justify a search order if the evidence sought to be destroyed should the respondent be put on notice, and then goes through the points that we make. So we make the distinction between the English position and the DIFC position, because in England, generally speaking, you can't get Norwich Pharmacal orders in support of foreign proceedings. Why not? Because the 1975 Act confines the common law in that regard. And so it doesn't come up very often, so at least not since 1975. And so you have a much broader power, we say. There's no corresponding legislation in the DIFC, and so the rules of court provide for the court to take evidence in support of foreign proceedings. However, they don't constitute legislation, so could not and do not purport to exclude any other rights parties have under the court law. And then consequently, deal with the position where the court had made Norwich Pharmacal orders against banks registered in the DIFC to assist in tracing funds passing through those banks' onshore accounts. So making the point that at that stage, and of course we're dealing here with 2018 and things have moved on, but at that stage there was precedent, albeit slim pickings, in which this court had made orders against Norwich Pharmacal grounds in support of proceedings that were going to be brought elsewhere. For the same reason, search orders can be made in support of non-DIFC proceedings against a respondent over whom the DIFC court has jurisdiction. And then I dealt with this to an extent at the ex parte hearing itself. You were taken to some of it, you weren't taken to all of it. If we go to page 1181, behind tab D19.
Sorry, page again?
1181.
1181, thank you.
There are some difficulties with this. Some of the confusion might arise from the way the note has been recorded. In particular, there's reference to affidavit when it should be Akhmedova, if you recall that case. But in any event, I don't think it matters too much. At 1181, at the bottom of the page, Your Honour will see what I say is I was going to say something very briefly about the injunction in support of non-DIFC proceedings. And I make the point that it's been an area of difficulty in the past. I say I only need this if I don't have the substantive claim against one of the defendants to the sufficient standard. And then I give some examples. You asked the question, why do you need it? And the point arose because properties, there might not be, it might be there's no claim against properties, and we might not be able to get to properties assets in another way. And what I do is I made the point that there is jurisdiction here because we have DIFC establishments as defendants. And I referred to the case of Akhmedova, and it's in the middle of the page on 1182. You can go back to it if you like, but I'll just summarize it. And I go on to address the question of how the court should exercise its powers once it knows that it has jurisdiction. And I took your honour to the primary legislation. In the middle of the report, you'll see a reference to the law of damages 36.5. That should be 36.3. And your honour asks the question, well, that particular provision, which we can go to if you like, doesn't expressly say anything about foreign proceedings. And my answer was the same as my answer today, which is that what it does is it gives the court power to grant interim remedies, even if there's no final remedy sought. You can find the provision we can look at it in a moment if you like, but the point being there that what was contemplated by that provision can't have been orders in support of arbitration, because that's dealt with in the arbitration law. So it could only be referencing orders in support of foreign proceedings. What I don't think I took your honour to, if your honour has a copy of the rules, is Rule 25.24, which expressly contemplates parties seeking interim remedies in support of non-DIFC proceedings. Well, I think that was part of what I said I think I referred to 30.65, not sure why. Yeah, so what I took you to in the skeleton argument for that hearing had been Rule 30.65, where an application is made to the court for an order for evidence to be obtained in the DIFC in support of foreign proceedings and so forth. So it was clear that once you've got jurisdiction, you can exercise these powers in support of foreign proceedings. And I'll come back to why you did it in a moment and whether it makes any difference that it's in support of foreign proceedings or it's in support of DIFC proceedings in a moment. But just to say, since that hearing, the DIFC courts have granted these sorts of applications on a number of occasions. And we've summarised some of those in the book DIFC Courts Practice. But always the difficulty in those cases has been finding jurisdiction, because so you get cases like Wintercap, which you might be familiar with, where the Securities and Exchange Commission got a freezing order in support of American security proceedings. And the difficulty for the court was to say, well, where's the jurisdiction? And that problem has been solved by Your Honour's judgment in Nest, because you can find the jurisdiction in the DIFC court rules, or indeed in the law of damages and remedies and so forth. But we don't have that problem here, because we know we've got defendants who are DIFC establishments, so the court has jurisdiction. It's just a question of power. But those cases illustrate that the court can certainly do that, and jurisdiction in fact can be found. So it was always clear that we sought the order from the outset on the alternative basis that it was needed in support of proceedings elsewhere. And of course it was envisaged at that stage that there would be substantive proceedings in the DIFC against the defendants. But that's not the issue. The point was that if we couldn't establish a claim to the necessary standard against one or other of these defendants, the orders could nevertheless be justified on Norwich Pharmacal principles or on principles of general applications for disclosure. And not only was the point raised at this stage, it was also raised on the collateral use application. And that's obviously so, it seems to me, because necessarily the court was being asked to exercise its powers to facilitate foreign proceedings, and that's how the defendants understood that to be the basis. And so there was discussion in the submissions to Your Honour about the application of the Norwich Pharmacal jurisdiction. So, for example, if we go to Bundle D, tab 9, it's page 255. what you're looking at is Mr. Davison's first witness statement submitted in response to the application for collateral use by the defendant. If we look at page 255, paragraph 68.2, you'll see they're responding. They clearly understood the application and the basis for it. Norwich Pharmacal applications, does you want to have that?
So not quite there yet. Go on, yeah.
So Norwich Pharmacal applications are normally made. This is the defendant's position against innocent third parties. Here the principal claim is against the Sanjay Shah defendants, and there's a risk of collateral attacks and so on. And at 68.4, the relief sought is too wide. Norwich Pharmacal principles don't extend to information obtained under compulsion in respect to the defendant's compliance with the freezing order. So the submission before you today was that it was that the applications were never put on the basis of Norwich Pharmacal principles. That's clearly wrong. And the response that comes back, if you go down to page 265, it is quite clear on that. Page 265, paragraphs 45 and 46, we're saying, dealing with where there was a point raised at that stage that saying we should have gone to the English courts, and the point we made there was that it's going to be difficult, or could be more difficult in the English courts because the court's powers are confined by the 1975 Act. But in any event, the sensible place to deal with this was in the DIFC court because it was Your Honour's order. And then at 26, and it's clear from 46, we're seeking it under Norwich Pharmacal grounds. And then if you go down to paragraph 56 on page 267, we respond to Mr. Davison's point. The Norwich Pharmacal applications are normally made against innocent third parties. And that may be the case in England, where you can't usually get them in support of foreign proceedings, but the test applied is whether the respondent's mixed up in the wrongdoing, so as to facilitate it, whether innocently or not. And there's no doubt that the relief is available against parties against whom the applicant has a cause of action, British Steel and Granada Television. So we make the point that there are those wider powers. So it's not right that the application wasn't put on that basis and wasn't argued on that basis. And the point that's raised here is my learned friend's second point that he raises in his skeleton. He says Norwich Pharmacal applications are only available against non-parties, he says. And in this case, the defendants are parties. Well, that misses the premise, because where we are at the moment is on the basis, what I'm dealing with now, is on the basis that he's right, that we can't succeed in England or DIFC. And so at that point, the defendant would be non-parties in this jurisdiction. So his case is that the claim here would be bound to fail. So you have to suspend the search order. The response is it isn't bound to fail. In fact, it's stronger than ever before, and I'll come on to that. But even if it failed, the order would be justified on Norwich Pharmacal grounds. So on that premise, the defendants would not be a party to the substantive proceedings. But in any event, as we say here in this witness evidence, it is not right that only innocent parties can be respondents. It's wrong, and that's very clear from the British Steel decision. And I won't take you back to it unless you'd like to see it, but I can give you the references if it's helpful, Your Honour.
No, I don't need them. Okay.
I'm grateful. And then the third point that's taken against me is it's said that the jurisdiction has nothing to do, the Norwich Pharmacal jurisdiction has nothing to do with search orders. So in other words, you can't get a search order on Norwich Pharmacal grounds. That is also wrong, and we know that from Abella and Badarani, paragraph 33, which makes clear that whatever basis a document production order is founded on, you can get a search order in appropriate circumstances. The appropriate circumstances being the concern of destruction of evidence and so on, the ordinary sort. That's paragraph 33 of Badarani at page 2060. So even if the search order couldn't be maintained on the basis that there will be a claim and judgment in the DIFC, there's no reason whatsoever for refusing to consider the alternative basis now and decide that there's strong evidence that the defendants were mixed up in wrongdoing. innocently or not, and maintain the order on that basis. Now, obviously, we say they weren't innocently mixed up. It's also relevant when you come to consider this aspect of it. Your Honour takes notice of the point that we're not asking you for permission to enter premises at this stage, which is the moment of greatest intrusion. What we are asking to do is continue using documents which we already have, many of which are public, and which Your Honour would have wide powers to order, either under the Norwich Pharmacal basis or under the rule that my learned friend refers to, which is 2852 of the DIFC court rules, which provides for orders against non-parties. And all that is required there is that the documents of which production is sought are likely to support the case of the applicant or adversely affect the case of one of the other parties to the proceedings, and production is necessary in order to dispose fairly of the claim or to save costs. So that is what we're ultimately saying. If it could be justified simply on that basis, that the documents are likely to be relevant to foreign proceedings, then we could get a search order on that basis if we needed a search order at this stage. We don't need a search order at this stage because there's no risk of destruction of documents. But as to the further use of the documents, what Your Honour shouldn't be seeking to do is somehow punish the applicant for its initial success and subsequent pending failure in the English courts by unwinding a position that Your Honour would have been open to at that early stage. So in terms of the assessment and the fundamental question, what has changed in this assessment as a result of what's happened in England? Nothing has changed for the worse from SKAT's perspective in relation to that basis for granting orders and permission to use documents, disclosure orders, ultimately. Indeed, we say the position is much improved because we do now have evidence, that direct evidence, we say, that the trades are fictitious. And I just wanted to show you just a few short bits of that, if I may. The first bit I wanted to show you was Mr. Cross's witness statement where he summarises it, which is page 618. And I'll do this as quickly as I can. I'm not going to trawl you through all of the documents.
Yeah. Paragraph
66 and 67. He says that they obtained Mr. Shah's working papers showing the mechanics of the fraud at each level. It revealed a scheme orchestrated by Mr. Shah by executing a large series of complex but ultimately circular trades to create the false impression that the applicants were genuine shareholders in Danish listed companies, when the applicants were not genuine shareholders, had never received any dividends, and so had never paid any tax to support a tax refund. Within the ELYSIUM documents, there was even found a document setting out the entirely circular nature of the transactions. And then at 67, he makes the point there's a lot of this material and gives some illustrations, including those set out in the Deloitte report, which is an English version of one of several reports submitted to the Dubai courts. If we go to the document first that he refers to, paragraph 66, you'll see what he's talking about. It's at page 873. So the point of this is that what it is showing is a series of transactions which go round in a circle, and there's no entry point for shares. All there is a series of circular transactions which each lay a paper trail, and to create the impression of a genuine series of share transactions, when in fact there were no shares to begin with. And so this is the scheme. This is how it works. You've got a document that came out of the search which shows that really the only interaction with SKAT is not in receiving any dividends and paying any tax. It's in getting money back out at the other end. The Deloitte report itself starts at 874, and again, I won't show you very much of this, just a few bits and pieces, if I may. If we go down to 887 and paragraph 22.6, you will see what is summarized there. So Sanjay Shah attempted to create a false sense of legitimacy about the scheme by executing a series of circular trades that created false impression that the WHT applicants had actually owned shares in Danish listed companies as falsely set out in documentation, which was submitted to SKAT. The scheme could not have succeeded had Sanjay Shah and his close associates not arranged for the submission of falsified documents, such as dividend credit advice, which stated that the shares were owned, despite no actual shares being involved in the circular loop transactions, to SKAT requesting refunds. And then 2.7, in fact, the WHT applicants never held, and then reaches those conclusions, but then goes into detail about the mechanics, because what has happened is that from the documents, we constitute a large number of these actual circular transactions, and so find each document, each transactional document in the transaction and evidence of those. If you go down to 898, you'll see where we've already got to, and you can see the mechanics of the scheme. And so it's paragraphs 249 and onwards, and deals with what we found in the documents. It says the scheme is not actually as complex as it appears. The supposed trades were not in fact a genuine purchase and sale of shares that ever existed. Rather, Sanjay Shah and his close associates executed circular loop transactions, which internally purported to trade very large positions of Danish listed companies between themselves, with no party within the circular loop actually owning any shares in the first place. And it's not just being able to reconstitute those loops, which has been assisted by the search documents. You'll see at 250 some further examples. We've identified several internal emails and spreadsheets at SCP which contain purported trading records involving the WHT applications and a number of counterparties, and they've traced that round, and then you'll see a reference, I think, further down to commentary on that by the Sanjay Shah defendants, and you see at 252 here, SCP set up its own, that's Solar Capital, set up its own internal trade approval system so that the circular loop transactions could be executed on their own private system and be cleared automatically without the need for external parties. And all of this is dealt with further on in increasing levels of detail. But the point is that when I came before Your Honour in 2018, we had fragments of the picture. And what has happened as a result of these documents is we've been able to build, and that process is ongoing, but build very many of these circular loop transactions that underpinned each of the WHT applications, so the tax refund applications. It is we say, a compelling case. You've got all of this evidence, it's out there before you today, and there is absolutely no response to it whatsoever on these issues. There's no attempt made to demonstrate ownership, even though it's right to say that ownership is alleged in the DIFC court proceedings. No doubt there's basis for that, but we've not seen it. In correspondence, what has been said is effectively to concede the materiality of this documentation. So in correspondence, and we've recited it in our skeleton, it's at page 1169. I don't need to take it to you to it, but basically the defendant's lawyers say we've got little doubt that the documents are of real use to your client in other jurisdictions. The only use we want to put them to is to prove our case in other jurisdictions. And they say that's precisely the prejudice that they would suffer as a result of that use. So in support, if we have to get to this point of a further basis, if we need it, for maintaining the orders, we rely on all of the reasons that Your Honour gave in permitting the collateral use order. None of those are challenged, and they will justify, we say, maintaining the use of the order, even if it now needs to be maintained on this alternative basis. Just to show you those reasons, I promised I would come back to it. It's at E26 and it's page 1353. You said paragraph 4, there's no prejudice to the defendants. Does you want to have that? Sorry, I can't actually hear Your Honour. I'm not sure whether it's me.
No, I'm still finding my way, I'm afraid.
I'm hoping that I'll only have another 10 minutes or so for you, subject to any questions that you have.
Yeah, I'm on 1353.
So these are your reasons for granting the orders for collateral use, and all of those reasons are very equally supportive of the application that's being made here. So paragraph 1 is justice requires that the defendant be permitted to use the documents disclosed in the DIFC. It's a very general statement, but it's one that is powerful. Ultimately, what we want to do is show the court the truth of what happened. Paragraph 4, there's no prejudice to the defendants in making the orders, since issue estoppel will only arise in relation to the Malaysian or US proceedings if the defendants are party or privy to those proceedings within the meaning of the doctrine of res judicata issue estoppel. Paragraph 5 it makes the point that any recovery from those defendants in the US or Malaysia will actually help the defendants who are the defendants today. In fact, it's only the first defendant who makes this application. Paragraph 6 and 7 dealt with specific concerns that were expressed and aren't repeated, that the defendants wouldn't be able to explain the documents to the foreign court, so those aren't relevant. Paragraph 8 emphasised the breadth of Your Honour's the court's powers, so long as the documents aren't privileged, and obviously lots of care have been taken in relation to that. And then dealt with paragraph 9 was about practicality, because there was a suggestion that there ought to be a relevance filter at this stage. And then 10, it would be wholly unjust if the defendants were able to supply the defence to the US and Malaysia with documents which support their case at their option, without the courts there having the benefit of seeing the whole picture, which emerges from the documents. All of those reasons apply here, even more so now that 10 million documents have gone to the defendants in the US. It's right that they haven't been deployed to that extent in Malaysia. But there's a clear danger that if we can't use documents, the court will only be given a partial picture. And that is wholly unjust, on Your Honour's words. In most of the jurisdictions, time for disclosure applications has now passed. So in the US, for example, SCAT now has probably lost the opportunity to obtain documents by making any disclosure applications in those proceedings, because it had all the documents. In relation to Dubai, my learned friend said, well, there's no disclosure process in Dubai, but that's not right. As Mr. Cross has said, it might be possible to get disclosure in the Dubai courts. There are facilities for that, but the defendants would need to be joined into those proceedings. And knowing the Dubai courts as they are, the likelihood is they would look at a DIFC establishment and say, we'll have no jurisdiction to make orders against that party. That's a matter for the DIFC courts. So there'd be a clear risk that that would not work. And even if it would work, it would be hugely wasteful and duplicative. So then there's the cat out of the bag point. I mean, in most proceedings, it's difficult to know how it is practically possible for SCAT to withdraw reliance on the documents. Your Honour said that you've read Mr. Cross's 8th witness statement. I'd ask you to have another look at it in due course, and I won't take you back to it, but just summarising some of the points that he makes. he makes the point in Dubai that it's not obviously possible at all to withdraw documents from Dubai court proceedings without withdrawing the whole of the claim. And there are 4 claims, one of which he says in terms directly rely on the documents. So I think solely rely on the documents, but all of them rely on the documents to a great extent. As I say, in America, the documents have been produced to the other parties, used in depositions. They've been used in applications to obtain evidence. They have not been used in Malaysia yet, as you pointed out, Your Honour, but they have, save to apply to amend, which application has not yet been heard. But as with all those jurisdictions, if we can't use the documents, we'll be unable to put our best foot forward and show the court properly what's happened. So in other words, the defendants will be more likely to get away with what we say is a massive fraud. In England, it appears to be accepted that it's not seriously contended that you should make any orders which affect England. But as I say, in all of these places, many of the documents are in practice beyond our control. And there'd have to be a detailed forensic exercise to understand where, for example, each pleading came from, to be able to give full effect to an order which said, actually, you have to unwind every reliance that you've used. If it was to be going forward, so if it's to be just forward-looking, you still, as I say, have that problem that you are only giving the courts a partial picture. So, for example, as I understand it, the process of reconstructing these circular loop transactions is not complete. A large number have been completed. I think over 1,000 have been completed, but they're not fully done yet. And so if you were to say all of that has to stop, we'll be able to show part, but not all, of the fraud. It's also, one would have to carefully craft the order, but also it's going to be difficult to understand why. For example, Your Honour would be able to say, well, those 10 million documents can be used in America because they've already been handed over, but now you can't use them to make your claims in Malaysia. So what's the solution to all of this? As I say, the obvious solution in my submission is to leave things as they are, because that's broadly or specifically what the parties agreed. But the proposal is that we could apply to stay all of these proceedings in all of these different jurisdictions. But this is an application by the defendants to prevent the claimants from doing something they already have permission to do. And what we said in response was, look at all this damage that would be done in those other proceedings if that were to happen. Not only would the courts not have the correct material, but harm will have been caused by the fact that we had the material and now we have to unuse it in a way. The response appears to be, well, you could just get a stay, and there's criticism of my client for not producing evidence of how that might be achieved. But that's to get it the wrong way around, because it's the defendant's case, it seems, that there could be stays and should be stays. So it's for the defendants to make the positive case that that would be the solution to all these problems. They make that case now in argument, so just a few days before the hearing, and say, oh, well, gotcha, there's no evidence on this point that we haven't raised yet, but here it is. We don't accept their assertion that there could be stays. It's not clear how that could be achieved. There was some suggestion of an anti-suit application in relation to Dubai, so Mr. Cross gives some evidence in relation to that. That's at page 622. But just to summarise, he explains the position in Dubai and says that a joint approach to the Dubai courts might have, by all the parties, might have a temporary effect, but it wouldn't last long. And there's been no suggestion by my learned friend, by his own clients, their associates, that anyone would agree to a stay, but it seems very unlikely that any stay would run for the course of the English appeal. And some of the claims are against third parties, so there's a spin-off, what we understand to be a spin-off fraud by former associates of Mr. Shah, who have set up their own WHT application fraud and have been merely going about that. It's not obvious why they would have any inclination to agree to any kind of stay if they understood that the alternative was that we weren't entitled to use the documents we need to make out the claim against them. But as I say, a stay is likely to be short-lived if it could be achieved. In America, we know, we don't have evidence of this because it wasn't raised, but we know that the judge has been reluctant to slow things down to get into line with other jurisdictions. But more to the point, there are 253 defendants in America, all of whom would have a position, and all of whom would see the point that if our SKAT's decision is either press forward with no documents or stay, then we should press forward with no documents. In Malaysia, there are 67 defendants. As I understand it, the most recent decision is currently the subject of their appeal, and that is going forward. That's about maintaining the freezing order, the revenue rule issue, and there was an issue about secrecy of the proceedings. But in Malaysia, there are 67 defendants. Again, what possible interest would they have in slowing things down? So again, all of this is premised on the suggestion that if we lose in England and then lose in Dubai, that somehow precludes Your Honour from allowing these documents to be obtained and used in other jurisdictions. It just doesn't. And really the submissions that are made against me on that, at least in the skeleton, are clearly wrong. The point that was made against me in oral argument was that this is somehow forum shopping. And again, it's a completely new argument. I hear Your Honour's point. It was a good point. Does it matter when it's raised? Well, yes, if my clients are being criticised for the conduct that they're undertaking, but it doesn't make sense in my submission. It was always, so to be clear, neither defendant is a defendant in Dubai, Malaysia, or the USA. So if we leave England to one side for the minute, because that seems to be irrelevant now. So it was always contemplated that the proceedings would go forward against other defendants in those three jurisdictions in parallel to the proceedings in England. And when I say always contemplated, I'm talking about the point in time when the consent order was issued, and indeed long before that, but in any event, it's clear because Your Honour gave collateral permission to make collateral use of the documents. So there are numerous reasons why the proceedings have had to be divided up in that way. Clearly, enforcement is one of those reasons, but the fundamental point of the argument is completely misplaced, because what we are trying to do is have our claim heard by some court in some forum. Hopefully that will still be England. But it cannot be forum shopping to have one forum say, we cannot hear your claim, and then go to another forum and ask that to hear the claim. And that, again, this comes down to a mischaracterization of the nature of the decision made by Mr. Justice Baker. We haven't been thrown out on the merits, we've been thrown out on the revenue rule. So we are not trying for different substantive results in different jurisdictions. And indeed, on the revenue rule, all we are trying for, as against these defendants, is different conclusions in the two different jurisdictions, England and the DIFC. But as I say, there is nothing wrong with that, because if the English court says we can't have our claim heard there, there's simply nothing wrong with us trying to find some other jurisdiction where we can have our claim heard. And the most obvious jurisdiction as far as these two defendants are concerned would obviously be this jurisdiction. So I don't accept the charge at all of forum shopping, and it's not a fair response to the situation that we find ourselves in. Your Honour, that was what I had to say, unless I'm told in the next 10 seconds that there's something else that I need to cover and I've missed. Those were my submissions on the application. No doubt you've got some questions.
If I accept your arguments to the full extent, then I understand why you say there's no difference between documents that have not been transmitted to you, but have been the subject of continuing search, sifting, and privilege review. But is there scope for any distinction at all between what you haven't yet seen?
Clearly, there's a distinction. There are practical considerations that apply to one and not the other. I can see that. We've embarked on a process of inspection of certain documents, spent money on it, spent time on it, and it will have informed the collective thinking. I don't have granular evidence about this, but one can see that if a document pops up during a document review, which is highly material, then it might well quickly find its way up to those who are making decisions about how the case should be framed. But clearly, none of that applies in relation to documents which we have not yet seen. And I have to accept that what I do say would be the catastrophic impact of withdrawing permission to use documents that are out there.
No, I understand.
Doesn't apply to those. Doesn't. So I accept that there is a distinction. Is it a principled reason not to just carry on as we were before? That depends on which bits of my arguments you accept and which bits you reject. But my sort of core justice submission is, what are they trying to achieve here? They're trying to ensure that cogent documents, which are evidence of fraud, don't come before courts which are considering those claims. If they're not cogent, if they're not evidence of fraud, they'll be irrelevant, and they either won't be deployed or they'll be quickly dismissed. But so this only bites on evidence in support of fraud, and one just has to ask the question: is that really what this court should be doing, protecting parties from that sort of exposure?
Well, if I accept your arguments about evidence in support of foreign proceedings, I see that point. But if one was looking solely at the position in England and thinking, now let's hold the ring until such time as the decision is taken on permission to appeal or by a court of appeal, is there any real prejudice to you?
Well,
not seeing what's being transmitted. I'm saying in one sense you don't know because you don't know what the document is saying.
So we don't know what's in the documents. I think in terms of what hasn't been provided to us, I may be speaking out of turn, but I think it's about 200,000 documents, which is obviously a lot of documents, but it's a small part of the whole.
But it's a cost. He says 200,000, I think. Yeah.
Yes. So what's the prejudice? The prejudice is we don't know how long the Court of Appeal is going to take to determine this. It might take a long time. It might take a short time. If it takes a year, if it takes 2 years, things will move on in those other jurisdictions, and they ought to move on in those other jurisdictions, and we won't be in a position to produce all of this evidence. But no, I mean, I hear your Honour's point. It is lesser prejudice. It is lesser prejudice. I accept that. Is it prejudice? It depends what's in it. But then that bites both ways, doesn't it? Because if there's nothing in it, then why not? And if there is something in it, then there's good reason.
Yes, but well, I think it all depends on the point as to evidence in support of foreign proceedings, doesn't it?
So let me try and help a bit more on the situation. If you assume that I'm wrong about evidence in support of foreign proceedings, then where are we? Are we just taking pragmatic orders to hold the ring to see where we get to in England? Then I can see the logic. I think one just in being pragmatic of saying, fine, let's just pause where we are. But would there be prejudice? There could be, but it would be less, definitely. In terms of where that dividing line would be, if it was at the line between what we'd received, then that would be considerably less prejudice than if it's what we've quotes deployed, whatever that may mean. Because that question, that dividing line in a case of this magnitude is going to be very hard to draw, and there's going to be a small industry. You've seen what happened with the privilege review. There'll be a small industry growing up around that.
Understood. Yes. All right, thank you very much. Mr. Jones, I'm going to take a 3-minute adjournment.
Certainly. Thank you. Well, we're all back, I think.
Please do carry on.
I promised you I would be short in reply, and I will do my best. As ever, they're going to be a series of short, random points picking up matters that I have noted.
Sure.
First thing is, I had eschewed myself holding the ring as an expression I wanted to use, but I don't know why. Just because perhaps it seemed. Well, I'm not sure why I didn't use it, but it seems to me, if I may say so, entirely the right thing. So, to what extent you want to hold the ring are all matters of your discretion, and I don't need to say more about that. I've put my case as high as I can. I've accepted the distinctions between 3 categories of documents: those seen and deployed, those seen and not deployed, and those not seen. And you have my submissions about that. But I do invite you to do your best to hold the ring for all the reasons I've given. So can I just go back to our 1356, page 1356 of the bundle, and just make some comments on this threshold point that Mr. Montague-Smith spent a while with, concentrating on what he said was the difference between 2.5b of the agreement and paragraph 4 of the order.
Yeah.
Now, the difficulty we've got here is that paragraph 4 plainly says what it says. It can only have one meaning, and that is the meaning that I have suggested it has. Recital B in the agreement only has one meaning and supports paragraph 4. So then we get to an odd situation where Mr. Montague-Smith is required to go to clause 2.5 little b, B for Bravo, on page 1361, and say that from that you are to back calculate the proper construction of clause 4. Now that cannot possibly be right, if for no other reason then if that was so, you wouldn't actually need clause 4 at all. There'd be no reason why 2.5b wasn't in the order. So the fact that those clauses, or one paragraph in the order and one clause in the agreement appear, and they appear in different terms, actually proves why we're right, not why we're wrong. The second point I wanted to deal with was the going back up to 1356, please. So this is clause 2 of the order, which we spent a bit of time on earlier on. And this is 2A. I simply, if I would say so, do not understand how 2A can be read as keeping in a play in full force and effect every part of every previous order that you made, except paragraph 25 or its equivalent. The paragraph number doesn't matter. I simply don't understand why that would be so, and I didn't hear any reason why it would be so. But in any event, why would one need clause 2A in this agreement? One would need clause 2A in this agreement to ensure that everyone was on the same page, that the orders did not fall with the stay. So on the basis that the claim is being stayed and is no longer to be active in the DIFC, possibly for some years, and if the trial had gone its full length, it would have been through until 2024, so 5 years, 6 years maybe. What one actually needs is clause 2A to ensure that the orders stay with the DIFC and they remain in force. They are still valid, they're effective. They haven't fallen with the stay. The basis upon which they're valid and effective is then clear under 2A, and one cannot pick and mix here. either the entire order is or the entire order isn't. What SCAT has tried to do is to read it as being the order remains in force for the purposes of protecting SCAT, but for no other purpose. Well, that just can't be right, and there's no mandate for that. But what we then find is what we get in 2B and 2C. So we know that our obligation to comply, and in fact SCAT's obligation to comply, because it's not just on us, is included in 2C, and 2C includes the ability to vary. So SCAT's difficulty here is that it's saying that some sort of small variation might be permitted, but a hold the ring variation of the type we seek, which is not a discharge, is somehow not a variation. So what is being advanced before you is that you are to assume in words which we haven't got a clue about, sitting behind clause 2A, B, and C, are two categories of variation, one that's permitted and one that's not permitted. And for the life of me, I speaking of myself, simply cannot see any basis upon which that could be pursued. Now, our application is not a breach of 2A, because that's effectively what's been said, for all the reasons that I've just provided you. So it is right, and Mr. Montague-Smith, it's a good forensic point. It's nothing more than a jury point with respect to him, but I understand why he makes it. That we have in the past said we want to vary the conduct of claims agreement, but you'll have seen how that's happened. Mr. Waters' witness statement, in fact, says we want to vary the order and the conduct of claims agreement. So we haven't suddenly switched allegiance from one document to the other. But in a sense, what we're looking at here is one single, something that is in a single document. And the fact that I have chosen today, which are what I think to be perfectly proper reasons, and explained in our letter of the 15th of July, to concentrate on the order is perfectly justified. It doesn't actually mean that our arguments on the order are wrong, just because we put forward other possibilities earlier and haven't pursued them. So for all those reasons, I still, for my part, reject the proposition that we can't make this application, that there is some sort of threshold that we can't overcome. Another quick point, you asked Mr. Montague-Smith whether he knew why Mr. Justice Andrew Baker had used the language he used. And I can't say, in fact, more than is on the face of the judgment. But if it's of any value to your honour at all, I can give you what my instinctive reason for it is, having sat through the trial. And it's only this, that there is it a question of pure jurisdiction, which is how it was to be found originally in the textbooks? Well, the answer, everyone thinks no, but that description was used. Then we move from jurisdiction to justiciability, which I thought I understood, but then there are different views about that. Then there's the question of whether it's a principle of judicial restraint, which I think Mr. Justice Andrew Baker did recognise as well in his judgment. And then finally, you get on to his preference for admissibility or inadmissibility, as he would call it. And my feeling is that what he was trying to do was to concentrate on something which fed his principal analysis. Your Lordship will know, Your Honour will know from the judgment that he was very keen to keep the first part of the judgment dealing with the matter of core principle. And then he took all sorts of subsidiary arguments, such as the use of public powers and comity and so on and so forth, and put them all in an appendix, because for him, they didn't really get to grips with what he thought the correct issue was. And it may well be that he was trying to use the language which for him supported, if you like, not supported, but identified more easily the core question that he wanted to focus on. But because if you're talking about comity, you might be driven to judicial restraint. If you're talking about public, and so on and so forth. My impression is that's what he was doing. But I do agree with Mr. Montague-Smith. I don't think there's anything in it ultimately, because I don't think there's anything underlying why he did it, which is only be this talk really to the learned judge in London, of relevance to what your honour's considering. But I only pass that on as a possible justification for it. And also, let me just mention something very quickly about the Deloitte report and what has been said about share transactions. So it is, in a sense, very frustrating and very infuriating for the defence team in this case to see trotted out the plan, what's called the circular plan, with the little arrows in it. It's now pleaded in London. It's trotted out as being the be-all and end-all. From that, you can see the clear existence of this fraud. With the greatest respect, it's all nonsense. It is as if SKAT has gone back 35 or 40 years and expects you to have a share certificate with wiggly writing around the outside and italic script in the middle. Life isn't like that. The shares exist as screen transactions. When Mr. Justice Andrew Baker looked at this, he concluded that the substance of the arguments that were given rise to about whether there had or had not been justification for these trades on the basis of their validity was going to occupy him for 6 weeks starting on the 24th of October 2021. Now, and that was going to be with experts from at least 3 parties. So when it is said, for example, as Mr. Montague Smith said, that there has been a complete failure to give an answer to this schedule, that is just wrong. There are significant pleadings in London, significant expert issues in London, gone over in great detail by the trial judge, who then ordered us to spend 6 weeks exploring it all. And it's to be assumed, I would hope, that he thought that was an exercise of some validity.
Well, you may get very excited by this, Mr. Jones, but it doesn't concern me at all today.
Well, I'm very grateful. I'm grateful because, look, I'm only getting excited about it because my client's listening to it and thinking this is.
The merits of the quote fraud claim don't play any part in my decision today.
Well, I'm very, very grateful. And insofar as you've been taken to Deloitte, all I wanted to say is we didn't see Deloitte, of course, until just under a month ago. And we didn't see the schedules, I think, until Monday of this week. But I don't mean that to be in any sense critical. I've said what I wanted to say about that, and I need say no more. So the burden of my song, let me just deal with one very short point, which was what to do about the existence of a revenue rule at all in the DIFC. It was said to be a sort of rather weak point that I'd made. I hoped it wasn't a weak point. All I was saying is it's no purpose of mine to ask you to determine the revenue rule, because I don't think we have to. We both agree it can't be done today anyway. The issue between us about if it should be done at all, is it to be after the stay or could it be before the stay? And it seems to me crystal clear that you could decide, not in the context of the claim because the claim is stayed, but in the context of an application, for example, such as this one, if you thought it valuable, whether a revenue rule existed at all in the DIFC. Now, I'm not advocating that. It was just me saying it doesn't seem to me that it's a binary state, that it's got to be done, if at all, after the lifting of the stay. What you would have to wait until after the stay to deal with is whether, if a revenue rule exists in the DIFC, this claim falls within it. That would be covered by the stay, but not the existence of the revenue rule per se. So I'm not inviting you to do that. I'm just explaining why I think there is there would be, should you wish to do so, a machinery for you to debate that with the parties and make a finding on it in advance of the lifting of the stay. But that is not my purpose.
What would be the advantage of that? Doing it earlier?
Well, I suppose it would be definitional one way, because if you concluded, if you concluded, for example, let's suppose you concluded against me on paragraph 4, and you then concluded against me on, and I'm going to call it the moot point. It's not actually a moot point because it would be for the purposes of this application. But if you were to convene a hearing and then conclude that the DIFC did not have a revenue rule, then it would have some utility, potentially. If you decided it does have a revenue rule, well, then it wouldn't be definitional that way, or dispositive, I should say, one way, only dispositive. So that's the only reason. I don't want to spend time on it because it isn't my case. I'm just trying to clarify what I was saying. So that then takes me back to the famous paragraph 4, and at the moment, I'm afraid I've heard nothing which dissuades me from the value of the submissions that I've made. But this is not about enforcement. This is all about what is going to happen in the DIFC court depending on what happens in England. And for example, well, let me just float a possibility. Is it seriously being said that if for some procedural misdemeanor or series of misdemeanors, the Sanjay Shah defendants were debarred from defending in England, and judgment was entered against them, that SCAT would be saying to you, I'm sorry, that is of no value to us in the DIFC. We're going to have to run it all over again if we want anything from you. So you could test paragraph 4 in a number of different ways, and it doesn't matter how you test it, what you will come back to is the proposition that we are entitled to have entered in the DIFC what is in fact the order in London. So you can't enter a judgment. And indeed, none of us could have signed up to an order, and I'm sure Your Honour would not have done, which purported to enter into the jurisprudence of the DIFC, a judgment of a foreign judge in a different country. The judgment per se is not going to be entered. The judgment ends up with the dismissal of the claim. That is what is going to be entered, and that's what paragraph 4 was designed plainly to deal with. So, you want to, I don't think I'm going to spend any further time on the bit, because in a sense, what I will now be saying is repetitive, I think, of what I've said already. I think I've covered additional points that have arisen. And Your Honour has decades of experience, 2 experienced advocates. We've said what we wanted to say, and at the end of the day, if these are points of construction, there's a limit to what you can say about them, and if they're points of discretion, I suspect you've already got a shrewd idea where you might want to go with all or parts of it. So I'm happy to answer any further questions you wish to put to me, but as we're half an hour at least over our allotted time, I'm happy to stand down and rest on my principal submissions.
Can I just ask you, I'm not conscious that I've seen the order made in London as opposed to the judgment.
Your Lordship may well be right.
Is there an order? There must be an order, presumably.
There is an order. Yes, there is. I
don't think it's going to affect my decision, but I would be interested in seeing it because it
yes,
may be of considerable relevance in the future.
Yes, I entirely understand. I won't try and search for it now because I would be able to search for it on Opus, but it will distract me. But within probably 15 minutes, we'll be able to provide a copy in PDF format, I imagine, from the parties.
Thank you. If it can just be sent to me or to the court by email, that would be fine.
Of course.
Thank you very much.
Absolutely, of course.
All right. Well, I'm going to reserve judgment, but I shall write it during the course of the afternoon. So you should get something. It depends on how the court works in the weekend in Dubai and so on, but you'll get something within the next few days in any event.
Well, I'm very, very grateful, and thank you so much for sitting a little bit longer than we had planned.
No, not a problem at all, but thank you both for your submissions and your help. I'm grateful to you both.
Thank you, Your Honour.
All right, well, if you'd like to sign out, then I can have a quick word with, if everybody will sign out other than the court staff, then I can talk to them and you can go and have some lunch or whatever is appropriate.
Thank you very much.
Well, thank you very much indeed. Thank you again.
Bye-bye.
Yes, Judge Sir Jeremy. I believe everyone's left the hearing now.
Right. Okay. Well, that looks fine. I shall draft some ruling this afternoon with reasons, which won't actually be terribly long, I don't think, but you won't get it before closing time at your time, because you're pretty much closing time now. But it should get to you tomorrow, and then it's a question of formatting it in the form of that you want. But you may be able to get it out tomorrow. It may have to wait till after the weekend, but that's fine. There's no mad rush about it.
Okay.
Okay. Thank you very much for your help. Very, very grateful. And
Thank you very much.
see you in due course, one way or another.
I do hope so.
Very good.
Take care.
Right. Thank you.
Bye.
Bye. Bye.